Thank you, Father God, for this opportunity. Just finish that game.
Good morning. This is Attorney Alex Taubes. Can you hear me?
Yes, Mr. Thomas, good morning.
We hear you. Alan, can you confirm, have you heard from the state's attorney's office?
I have not as of yet, but I'm going to try to connect Ms. Walcott.
Thank you. Good morning, Attorney Taubes. Mr. Ramos.
Good morning.
You see that?
Yeah, read it.
It's on. It's a, yep.
Muted?
Nope, we're not muted.
Predate.
Looks like we do have the state's attorney on the line.
Foundation. So I
But yeah, you're good.
Yeah.
There you go.
Right, everyone can hear me?
Yes,
All right. First,
Yes.
Get started.
Now I feel bad.
Good morning. This is the December 17th, 2025 commutation session of the Board of Pardons and Paroles being held at Cheshire Correctional Institution. My name is Parole Officer Dickey, and I am the hearing coordinator for today's session. Additional board staff are also present to assist with the hearing. Presiding over today's hearing will be Chairperson Zaccagnini, who will now say a few words.
Good morning. My name is Jennifer Medina Zaccanini. Joining me today are board members Rafaro Berry and Robert Sazowskis. Welcome to everyone. The people of the state of Connecticut have vested the Board of Pardons and Paroles with extraordinary power to grant commutations of punishment, releases, and pardons, conditioned or absolute, for convictions in the state. A commutation, if granted, may result in a reduction of your sentence. The board may also decide to release you from your sentence. In considering whether to grant any form of relief, the board looks at, among other things, the nature and seriousness of the crime, its impact on any victim, the length of time that has elapsed since the commission of the crime, any efforts the applicant has made towards rehabilitation during their incarceration, and any compelling or exceptional circumstances. As an applicant to be heard today, your case has been reviewed thoroughly by the board. I wish you the best. Ms. Dickey?
Please note, if there have been any changes to your conviction status or you have had any new arrests since filing your application for relief with the board, you must disclose such information to the board today. Additionally, without exception, any form of commutation granted by the board today may be revoked at any time for good cause shown. As stated by the chair, your application has been fully reviewed by the board. The board is familiar with your case, has read and examined your written submissions, including any written letters in support or against your application for a commutation. The panel members have copies of those letters in their files and have completely and thoroughly reviewed those files in preparation for today's hearing. There is no need to repeat what has already been submitted in writing. The purpose of your appearance today is to allow you to make a brief presentation to the board while adding any information that is not already in your file. You are required to tell the board why you are seeking relief. The board may issue a decision to you today. However, you will receive a letter by mail informing you of the board's decision within 2 weeks. Mr. Ramos, as part of your testimony, you are required to be sworn in. Please raise your right hand. The appropriate response to this testament is I do. You solemnly swear and sincerely affirm, as the case may be, that the evidence you shall give shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon the penalty of perjury.
I do.
Thank you. Mr. Ramos, please state your name and inmate number clearly for the record.
My name is Julio Ramos. My email number is 163-865.
Okay, you may proceed to explain why you believe you deserve relief. However, if you wish to have your attorney make an opening statement, you may do so instead. Then you may address the board after. The decision is yours.
Yes. Go ahead, Mr. Alice. If you want me to go first, it won't matter though.
I'll give a brief opening statement. In 1997, a forensic psychiatrist opened a manila folder with the name Julio Ramos on the tab. He reviewed the records inside. He wrote his report. He concluded that my client had no significant mental health issues, no meaningful substance abuse history. The problem, as the appellate court would later call a regrettable mistake, the records belonged to a different Julio Ramos, a different birth date, a different life, a different brain. That folder closed, and this Julio Ramos got 50 years of imprisonment. Today, you open a new folder, a different one, the right one. After this speech is over, I will not speak again. You'll hear from him, you'll hear from the prosecutor, and you may hear from the victim's advocate speaking for a family whose loss is permanent and real. I will have no chance to speak further, but I want to give you a few things to carry through for the rest of this hearing. First, a man died on June 27, 1996, and his family's pain did not end that night. It has continued for 29 years. The grief that belongs in this room, we have never asked anyone to forget it. Mr. Ramos has never minimized his role in this crime. The night of this offense, Mr. Ramos turned a gun on himself because he could not bear what he had done. He survived and has carried the weight of his remorse every day since, not as a strategy for this hearing, but as a fact of his character. Second, when Mr. Ramos answers your questions today, you will hear a heavy accent. He thinks in Spanish. He writes with clarity in English. His application, his letters, his program certificates show this. But speaking aloud, under pressure, in a second language, to a board that holds his future, that is different. If he pauses, it is not evasion. If he struggles for a word, it is not to hide anything from you. Judge him by the substance of what he says. His record shows his mind. His answers will show you who he has become. Third, the prosecutor will argue that 50 years was the right sentence and remains the right sentence. That is the prosecutor's job. But I ask you to remember what the sentencing court did not know. The command hallucinations, the voices telling him, do it, documented in prison intake records. The 15-bag-a-day heroin addiction, the PCP psychosis, the traumatic brain injury, all of it hidden from the courts by a switched file. The prosecutor will speak about the crime. I am asking you to remember the context that was erased originally. Fourth, and finally, perhaps most importantly, remember what 29 years has built for Mr. Julio Ramos. Program after program completed. A man entrusted by correctional staff to run a housing unit, to join the honor unit. Evaluations that use words like integrity and mentor. A man who became a father and now a grandfather. His son, another Julio Ramos, one who he would be proud to be mistaken for, has a daughter, a Connecticut state wrestling champion, his granddaughter. And she has never known that grandfather outside of him being incarcerated. And of course, finally, you have to consider that Mr. Ramos now embraces and has successfully used mental health resources within the Department of Correction by accessing, trusting, and receiving treatment from mental health professionals who he now knows he needs and who he has now already worked with to coordinate the provision of mental health resources if he is given the opportunity to be released. When everyone has spoken, you'll be left with a question. Is 50 years imposed based on a psychiatric evaluation of the wrong man on a defendant who was psychotic, addicted, and unrepresented in any meaningful way, but who has now transformed himself, sought mental health treatment for his conditions, and who is rehabilitated and shown true remorse? Has 29 years for that person earned a different answer? I believe that this record answers that. Mr. Ramos, the board is ready to hear your statement.
Okay, Attorney Taubes, just for the record, could you please state your name and juris number?
My name is Alexander Taubes, and my juris number is 437388.
Okay, Mr. Ramos, you may begin with your statement.
Good morning again. To begin, I want to acknowledge and take full responsibility for the death of Mr. Hashmi. I hold myself accountable for the pain that I caused his family by my senseless action. My words cannot express the shame, guilt, and regret that has tormented me for the past 29 and a half years. Every day I pray for forgiveness from God and Mr. Hashmi's family. I pray for their healing, for God to ease their suffering and provide them with comfort. I cannot make sense of my actions on the day that I decide to arm myself with a weapon and go to the gas station where Mr. Hashmi worked. I was numb to my own trauma and abuse when I committed the senseless and cold act that caused an innocent, hardworking man and husband to lose his life. I'm also remorseful for the emotional trauma and economic impact that my destructive behavior had on my community. I apologize to my family for the disgrace that they were forced to endure over the decades. Again, to Mr. Hashmi's family, I'm sincerely sorry for all you having to relive that terrible day, and I thank you for the opportunity to be here today. To give you a bit of my history, I was born in Caguas, Puerto Rico. My parents raised me and my younger sister to the very best of their ability. My mom was a homemaker, and my father worked hard as a carpenter and electrician. The majority of my dad's paycheck was spent on alcohol, and it was my grandparents who helped with food, clothing, and school supply. My father had a serious drinking problem. The more he drank, the harder time got, and he became extremely abusive. But he believed that I wasn't his son because I was born with a much lighter complexion than him, my mother, and my sister. I was mentally and physically abused whenever he drank, and that was often. I grew up to believe that I was a worthless and undeserving person in search of a better life we moved to the United States in 1981. By the time I started going to junior high school, my childhood trauma led me to turn to alcohol. I developed a taste for alcohol like my father did, and my life became unmanageable. I experimented with marijuana, hash, and cocaine. A few years later, I started using heroin, and before long, I was smoking PCP, sometimes laced with crack cocaine. I was overwhelmed by my weaknesses. My addiction got stronger, and I found myself strung out. I was lost, immature, bad at decision making, and had a need to be accepted by the worst of my peers. My negative self-image, low self-esteem, and growing drug habit turned into criminal tendencies. I was selfish and uncaring. This difficult character continued on to my arrest. When I came to prison, I was diagnosed with PTSD, major depression, and ADD. The thought never crossed my mind that I had mental health issues. Since then, I've been receiving mental health counseling and medication. I have completed a number of positive programs offered by the prison, such as Alternative to Violence, People Empowering People, and Voices. Incarcerated, I earned my high school diploma in 2004. And I know in Church's honor program where I continue to grow on my rehabilitation and helping others. I am currently participating in the honor discussion group. This weekly program explores the meaning of honesty, ownership, nobility, obligation, and respect. We are encouraged to define this quality, apply it to ourselves, and positively impact our immediate community. Today, I stand here before you as a responsible man with no excuses for my past behavior. I assure you that I'm not the same misguided young man from long ago. By consistently programming and aiming to better myself, I began to restore the morals and values that I lost along the way. The various programs that I took helped me to address my childhood trauma, develop character, and twisted belief. I've grown in my spirituality, and I have accepted Jesus Christ into my life as my personal Lord and Savior. I am a better person now. The lesson that I have learned over the years have helped me to form a solid re-entry plan. It's given the opportunity to prove myself worthy. I will first go to a halfway house where I can be assisted in slowly adjusting and reintegrating into society after all these years. I know that a lot of things have changed, and I'm sure that some are still the same. My sobriety and mental health, along with my freedom, is my biggest priority. I plan to protect them by continuing in my recovery and rehabilitation. I plan to get a sponsor and to regularly attend any programs and meetings, as well as mental health counseling and treatment. For my successful transition back into the community after incarceration, my mental health case manager, Rachel, and my addiction specialist, Mr. Acosta, have both agreed to write referrals to the Wheelers Adult Recovery Program. The program provides clients with a clinical case manager and a peer specialist to support in recovery. The specialist involves substance use and mental health disorder. The services that they offer include primary care, dental, mental health, medication for substance use disorder, and peer engagement. They also assist with vocational and academic programs, transportation to and from scheduled appointments, and employment referrals. Thank you all for this opportunity to set a new course in life, and I thank you for your time, for your energy and consideration. Thank you.
Okay, thank you, Attorney Ramos, for your statement, and Attorney Talbot for your statement. As I read in my opening statement, we are very well versed in your case. In preparation for today's hearing, we reviewed an extensive packet that included the police report, pre-sentence investigation, the court transcripts, In addition, your entire record from the Department of Correction, which includes your disciplinary report, history, all of your programs, certificates from those programs, work evaluations. We also received multiple letters of support, forced correspondence from Attorney Talbis, and the commutation summary from our officer, the officer who put together a packet and interviewed you. So we're very well versed in your case. We do have some questions for you, sir. When we're done with our questions, the state's attorney will have an opportunity to provide a statement. I will confirm at this time with the Office of Victim Services that outreach was completed and what the result of that was. Ms. De Jesus?
Yes, good morning. That
Good
is correct.
morning.
Outreach was done.
And
I
we
have
have
no
no
interest.
input today.
No
Oh,
input for today.
thank you very much, Ms. De Jesus. Okay, so if you're ready for our questions, we'll begin. You good?
Yes,
All right, Mr. Ramos. We'll begin with my
nervous.
colleague, Mr. Sazowskis. Thank you.
Very much, Madam Chair. Good morning, Mr. Ramos.
morning.
So I'm not going to relitigate the case, but I do want to go over some of the facts of what happened. We'll start there and then just move forward, okay?
Sure.
Okay. After reading through all of the files and your statement to the police reports, I just have a couple questions about some of the facts surrounding what happened. In your statement to the police about the murder, you said that you just wanted to get out and he wouldn't let you go. Do you remember that?
Yes. Yes, I do
This
remember.
was, they were asking you about why you were having a physical altercation before the gun was fired. You were saying that
Yes.
you were trying to get away from him, right?
Yes, that's correct.
Okay. So why were you trying to leave the store before the shot was fired? Why were you trying to leave?
My intention was never to hurt the person that I was robbing on that night. My intention was to get some money so I could take care of my drug addiction problem. Smoking really just told my mind like I couldn't reason right. So I'm not saying that I meant to hurt a person or I'm responsible for what I did, and I'm really sorry for it. The gun went off when we were struggling and before I ran out of the place.
I appreciate
Truly
your
sorry,
apology.
though, you know.
I appreciate your apology and your remorse, that you expressed now and in your opening statement also. But what I'm getting at is that you said that you were trying to get away from him, but then you shot him and then you did not leave. You did not leave the store, right? You went back around the counter and got the money.
That's a little cloudy, but I guess that's right. Yes.
Do you understand my confusion on it? Is that you say that the reason that you were fighting with him is because you're trying to leave the store, and then he ended up being shot by you in that incident. But after he's shot and is down on the floor, you don't leave. You actually go, back to the register and get the money. Is that an accurate depiction of what occurred? Do you remember?
Everything's a little cloudy, but yes, I wasn't on the right state of mind, but yes, I believe that's correct, though. If that's what it says, though.
Okay. All right. Something else that I read was that in the police report, it says that the bullet entered the victim behind the left ear. When you talk about it, you talk about him facing you, but he was shot in the back of the head. So I'm trying to understand if you remember what happened when the gun went off.
Honestly, I really can't remember, honestly. I know we were struggling. I don't know how it went up, but
From what the police say, he was facing away from you. He was not. He was shot in the back of the head, according to the report that I read.
we was debating. He was trying to grab my gun, so I don't know, in the middle of trying to talk to him or get away from him, that's when the gun went off, but.
Okay.
Oh, man, that's crushing my heart right now.
I understand it was 30 years ago, but I mean, these are the questions that I have after reading the report. I just wanted to see what you would say about these things. You know, this has come up in your opening statement, and I think I heard your attorney talk about it too. This next thing is that you said that you were so upset, horrified that night that you shot the victim later that night. Is that true?
Yes, I try to shoot myself after that because I didn't mean to shoot the person. I never meant to hurt anybody.
I know, but the thing is that I have trouble with is that if you were so horrified and upset about this, the next day you went out and did it again, you know, a couple of days later, and you hit someone else in the head with the gun, like in a violent way. That person could have been killed. You know, it was almost identical situation. A couple of days later, you did the same thing. I mean, that doesn't sound like a person that is horrified like you're describing, you know? Why would you go do it again if you were so upset about what you had done?
My addiction took over my life, sir. My addiction took, I didn't have no control of my addiction. At the time, I thought that was the fastest way. I don't even remember how a gun ended up in my hands because I don't remember where the gun came from. Up to this day, I still try to remember, and everything's like, you know, it's cloudy.
Okay. So now I'm going to move on to some questions about the gun, like you just said. In the pre-sentence investigation, this was a long time ago now, but you said, I don't like guns and I don't like violence. But when I read through some of the statements and the police reports, it sounds like you had a gun, you were hiding it in a park, and you were using it for crimes. Do you remember that?
No, sir.
You don't remember saying that you were hiding a gun in a park, in a local park, and that you would go to get it? You don't remember saying that?
No, sir.
So if you didn't like guns and you didn't like violence, why did you have a gun? Why were you committing violence?
Like I said, sir, it's my addiction took control over my life completely. Though I was on denial that I had a drug problem. I was on denial that there was help out there, and I didn't know how to get it. All I was thinking about my next high, how I was gonna get money. I wasn't thinking about who to go, who to rob. I wasn't thinking about none of that.
How do you think your actions have affected the victim's family over all these years?
I know it's been hard. I know that he had a son that has special needs, and for when I read on the victim's family letter, they was seeking for some money for some type of operation for his son, and up to this day I pray and I wonder if he ever was able to get his operation. I wonder how he's doing, but there's no way for me to reach out to them, and I wouldn't know if that would have been accepted by their family, because I know they're very upset with Mr. Hashmi's loss, though, you know. Like I said, he was a husband, a wife, a husband, a father that provided for the family. He was loved by the community. I never knew him personally, never met him, but I know their family are suffering. I know if my family has suffered, I have suffered. I know they're probably suffering the most because that person's no longer here.
Okay.
I'm sorry for Mr. Hashmi.
I appreciate your apology. You said it several times, and you appear sincere to me. I believe that you are sorry and you do feel remorseful. I'm going to move on to something else, Mr. Ramos. In the documents I reviewed, and your attorney talked about this next topic also. I found that the court has already determined that the mistake that your attorney spoke about on the medical records at the time of your sentencing did not warrant erasing your guilty plea or reopening your case, right? You've taken this back to court. If the
Yeah,
court
that's
has already if the court has already reviewed and ruled on that matter, why do you feel this is still an exceptional circumstance for us to consider?
Maybe the outcome of my or the sentencing would have been different if they would have known that I had a mental health problem, which I discovered when I became incarcerated. My drug addiction, it was totally out of control. Oh man, oh, it's hard. Everything is totally different. So probably if they would have evaluated me properly, they would have the outcome would have been differently. I'm not there to do that analysis, but
It did. I understand what happened. We read through all those documents, but it did appear that there was information that they knew that you were had a drug addiction at the time, right? That information was available. People knew that you had a drug problem at the time of your sentencing, right?
yes, but the psychiatrist spoke about that he didn't see that there was no mitigating circumstances, but he said that the drug really probably didn't have no side effect, but he said himself that on the statement that he's not familiar with the drug Illy, which has PCP on it. And that was the worst thing that I had ever done though. And well, I don't even want to know about any about no substance at all.
So you think that the lack of knowledge of the side effects of Illy and PCP at the time, contributed to the sentence that you have, that they didn't know enough about the drugs at that time?
Well, it would have been some good mitigating circumstances that would have explained the action that my action that were committed during those robberies.
Okay. Let's talk about your disciplinary reports. You have 22 disciplinary reports. The last one was back in 2018. So it's been like 8 years, right? You've done well since then.
Yes, almost 9 years. That's correct.
Yeah.
Thanks God for that.
Why did it take 22 years though for you to get to a point where you could be in the prison without disciplinary reports? Why did it take so long?
There was a time that I was lost. I was lost in a world where I had a lot of issues to deal with. Didn't know how to go about it. I was my pride avoided me to accept that I had a problem with my addiction, my behavior, my past behavior. That told myself the way that I carry myself totally different though, and I kept seeing the mental health doctor and they kept giving me different medication until they diagnosed me with what I have today. And being away from the negativity, I noticed that has helped me big time. When I accepted Jesus Christ like 10 years ago, I decided that this is not the life to live for nobody. I don't want this life to nobody. The rehabilitation comes from yourself. You're the one that has to be willing to change if you want a better life for yourself. So I decided to do whatever it takes to rehabilitate myself by any means necessary. Stay away from negative activities. If it's not for to better myself, I totally discard it out of my way. So I decided to take programs after programs, and I feel good about it. And I'm grateful that I'm in the honor program. That was my goal, because they had a lot of programs, more than population, and we are working right now to bring those programs to the general population little by little. So that's something that's been under discussion right now. But me personally, I'm grateful that I did it now. I wish I had done it earlier, but at the time I was struggling with my own demons.
Okay, so from 1996 to 2018, during that time when you had those 22 disciplinary reports, do you think that your behavior during that time was exceptional? Would you consider that to be exceptional?
No, I'm not proud to talk about those incidents because it was a time of ignorance, of being accepted by my peers, you know, and this is a different lifestyle that when you adjust to it, you just sometimes you have to do it to survive. But it's all in the mind, though. I learned to accept what I had done in my past, and I had to change it. So I was the one that had to take that step, not nobody else. If anybody else accept what I was doing, I was never going to change.
It took a long time. I mean, you know, I see people who the first couple of years, they struggle a little bit and then they make this change that you're talking about. You said you found Jesus Christ, became stronger in your faith about 10 years ago, all these things. And then you got into the honor unit. A lot of good things have happened in the last 8 years. You've done a lot of programs, you know, it just, like you said, it did take a while, you know.
Yes.
You completed a lot of programs. Which program do you think was most beneficial to you?
A lot of them helped me with a lot of aspects of my life. But tier 2 helped me a lot. Alternative to violence, which I mentioned on my letter, and voices. I said voices because it put me in the victim's shoes. Though I learned how he was feeling the day that I assaulted him. I went to rob him. I understand. I empathize with the family, what they was going through. Seeing her husband, our father, in a hospital. That helped me to build remorse, to accept what I did with more. Oh, I was angry at myself for what I did. People Empowering People also was a good program. It helped me on embracing parenthood. Teach me how to teach my kids, how to talk to them, how to encourage them. They all has their good. There's nothing wrong about none of them programs, but that don't happen a long time ago. So a lot of them I gotta read a little bit about them to go back to tell you more about the programs, though.
No, I understand. It's been a long time for some of these, you know. Talking about the fatherhood program, I see that you completed the program, right? And then did you take it a second time in 2023 or 2022?
Yes.
And it says that you were discharged.
Correct.
It says you were discharged without prejudice in the record that I have. What happened? Why did you not finish that program?
I got moved to another facility.
Okay. I have a similar question about tier 2. Second time you took it was in 2019. The note says here, absent safety and security. What happened in the second round of tier 2?
It was different. I was more like a mentor. I spoke about what I did at first on my tier 2 program, the basics. I teach people that they had to be accountable, and I said that they had a drug problem. You know, that's the first thing to do to move forward in life, though. You know, it teaches you about drug addiction and violence, how to prevent violence. But drug addiction and violence, it's like they go with each other. Like, I took it to refresh my mind, to help others get adapt to the program. I heard the additional service coordinator with the group.
So you didn't finish it in 2019? Did not finish the program?
Yeah, I finished it.
I mean, my notes say that you did not finish it, so I don't know. I was just curious if you recall what happened. It was in 2019.
2019, I was here.
Yeah.
I finished it. I didn't receive the certificate because I already did it at Madugo.
It looks like you're on the waiting list for New Thoughts program. Have you heard about when that might start?
No, not yet. We're waiting.
I've heard a lot of people say that's a helpful program.
They
Did you
all
put in
are.
for that? Did you put in
Yes.
for that, New Thoughts?
Yes, I also finished the honor program recently, so honor for discussion.
Right. And you went on and got your high school diploma while you're incarcerated, right?
Yes, that's correct.
I know your attorney spoke about your accent, but I'm not having any trouble understanding you, sir. Have you thought about taking college courses?
At the time right now, so many programs that I'm taking right now, I want to stay focusing in like the program that going to help me rehabilitate me and keep it from recidivism for my drug addiction and stuff like that.
Okay, understand. Are you working now in the facility?
I'm doing commercial cleaning.
How often do you do that?
5 days a week.
Is it during the daytime?
Yes.
So how do you go to programs? When do you do that?
Most of the programs they be like in afternoon or at night. That's a unit where people work in market shop and sign shop. So they be working during the day. So most of the programs they decided to do in the afternoon.
Okay. What do you think your biggest accomplishment has been since you've been in prison?
Right now, making it to the honor unit, which is hard. Obtaining good work report from officers and captains and lieutenants, which they're not easily given to people. And my change in life, that wherever I go, people look up to me like, hey, how you doing, Julio? Or this and that. You went to this program, or what happened about this program? You gonna work? And I advise some junkies too, but they got another unit, they call it the tree unit. I try to encourage them to be part of that. You know?
They're younger,
can be
right?
part of
Most of the people?
Yes. It gives me joy to help somebody else, though. It just made me feel good. I even heard the older people.
In your commutation application, when talking about your release plan, you said that I will continue to seek ways to atone. For example, I plan to engage in restorative justice programs possible. Can you explain?
Yes.
Can you explain that? What does that mean to you?
Yes. There's a lot of people incarcerated right now that they got a real long sentences. And if people really look carefully at the cases, some of them deserve to be heard again, and because there was unjustly sentenced, something with the cases went wrong, or they didn't look at some situation pertaining to the cases. And I want to make sure that people, there's a lot of people here that deserve a second chance in life, and they keep working at it, no matter how much time they got. They keep working to better themselves. They get an education, and I just don't want people to go through what I went through. If I could help it, you know, I want people to be judged the correct way, and if they did something, to assume the responsibility and take accountability for the action. and move forward.
Okay, Mr. Ramos, I appreciate you answering all my questions. And I appreciate all the programs you've done. You're doing good now. You know, I want you to continue that regardless of what happens. And I'm sure that all those younger inmates and those other people you're helping are appreciative of what you're doing. So thank you for answering my questions today. That's all I have, Madam Chair.
Thank you, Mr. Sadowskis. Okay, Mr. Ramos. We appreciate you speaking with us today. How long, sir, before you committed this crime had you been using drugs? Or do you know at what age, when did you start using drugs?
Wow, but it was like 16.
Okay, so about 10 years you had been using drugs. And I do see that during that time, you did have some convictions. So you were getting into trouble regularly as a result of your drug use?
Yes, ma'am, that's correct.
What was your assault second conviction for in '88?
Had an argument with my girlfriend. And yeah, I was like 16, close to 17.
Mm-hmm.
Some little arguments got out of control, but yes.
Okay. So during those 10 years, did you have any treatment for your substance abuse?
Yes, I partake in NA tier 2 programs, any
sorry.
type of
No,
program.
she's asking
I'm gonna
during,
interrupt you.
before.
During this 10 years between 16 and 26 when you committed this offense, were you involved in any interventions, any type of treatment for your drug use?
I don't remember exactly when I started going to programs. All I remember that when I started signing for programs, they kept telling me due to the length of my sentence.
No,
I
in the
wasn't a
community,
priority
sir. I'm going to stop you. Sorry. Before you came into prison, when you were 16 years old, and through the time until you committed this offense, you were involved in the criminal justice system. Had you taken any type of programming in the community?
No, so I wasn't aware of all the programs that they had out there. I never knew about assistance like to help you cope with your addiction, stuff like that.
Okay, and they never sent you through the courts or probation or anything like that?
I tried to go to an inpatient clinic, but at the time my insurance didn't cover for the cost of being on the drug program.
Okay. And why did you begin using drugs? How did you get involved in drug use?
Well, I really didn't have a father figure, and always it was poor choices, poor decisions that I made. Poor decision, like little by little, I started doing something else and something else. And see, you know, I was lost in that world, and I didn't know how to seek help. My pride stopped me from doing that. So I didn't recognize I had a problem.
Did you have any positive role models in your life?
Not really. My mother, which she helped me cook a lot. I learned how to cook real good. But I was by myself in Connecticut. My mother had left to Puerto Rico. My sister had left to Puerto Rico. My son's mother and my son had left to Florida. I didn't know how to look for them. Then they had this. I didn't know how to have. I don't even know how to use the internet right now. So I'll be lost. So I didn't know how to look for my son. Well, all I knew he was in Florida. Well, I didn't know how to look for him or find out where he was knowing.
Mm-hmm. Okay. I want to talk a little bit about your co-defendant, because early on you claimed that, you know, he had a strong influence on you, and that it was his idea to do this robbery, and he gave you the gun. Is that still? Do you still say that today?
When that happened, everything was happening so fast. Oh, brother.
Tell
Who
Okay,
is-
I'll ask you a different way. Sorry, sir, if this is a difficult question. And you stop me anytime you don't understand what I'm asking you. What was Mr. Wright's involvement in this offense?
Oh, he was driving the car. He didn't know I was going to rob the place.
Okay. Was it his gun or yours?
It was my gun.
Okay. Okay, because I did note that he got a very light sentence, and I wondered why. He only got 5 years. Okay, and I appreciate your honesty, sir. When is the last time you used drugs?
Well, that was a long time. Since I've been incarcerated, there was one time that I tested positive for some THC, and that was the time that the unit there was a lot of things in the unit. So I think it was almost like 20 years ago, 25 years ago.
Are you referring to the 2011 intoxication ticket, sir?
Yes, that's correct.
That would be 14 years ago. Okay,
14
so you
years.
used marijuana in that incident?
I didn't use it. There was so much in the unit that probably inhaling it so much probably cost to be like they say like 18% or THC levels on my system. So, but it's my fault because I couldn't move to another unit or stay
Okay.
away from it.
And
Even
the
if I
ticket
would,
that the conspiracy to convey contraband, what was that for?
that happened between some communication that I have with my girlfriend on the phone, and they thought I was trying to bring something into the facility, which I wasn't. And they're trying to go to this lady's house and tell her that she was seeing me, and at the time she was involved with somebody else, and I didn't want no drama for her life, so I accepted responsibility to what they was accusing me of.
So they listened to a recorded phone call and they thought you were trying to bring drugs into the facility?
Yeah, I heard I talk about somebody else in the phone, and they called us by a nickname Gordo, and they thought that person, I was trying to get something for that person on the phone, which wasn't true.
Okay. All right, so let's say you've been sober and clean now for the past 14, 15 years. How have you done that? Because we know there are drugs in the facility.
I went for negativity. If I know somebody else involved in negative activity, I just go the other way. If I see somebody argument, if I could escalate the argument by any way, shape, or form, I will do it. But if I see that it will implicate me in some way to harm me, or the way that I want to do my sentence right now, I will stay away as far as possible.
Okay.
And everything that they have programs, I try to be part of it so I could keep occupied. I don't want to be myself just not doing nothing. I read the Bible in myself. We go to Bible studies in a unit. But if I could take more programs and anything that they have, I'm taking it. I'm gonna take advantage of it. Anything to better myself.
Yeah,
It's never too late to learn something new.
agreed. When is the last time, sir, that you heard negative voices?
Been a long time since probably been 29 and a half. Well, like since 20 some years ago. All that happened pretty much at the beginning of my sentence, like the first few years.
Yeah. Okay. How long have you been with your current girlfriend?
That's the son of that's my son's mother. We've been connected through my whole life.
Right.
And now she's
Your
in
son
church.
is how old now? I'm sorry.
He's
Sorry, I don't mean to interrupt you. How old is your son now?
he was born in 87, so that what make him like 38 years old.
Wow.
He working.
Your girlfriend has stuck with you all this time. It's amazing.
She's a good woman. She's a good woman though, and she's a God-fearing woman too. So and that she she give me the strength. She's my motivation too. So she also keep me on the Bible, read this, read that. We study on the Bible on the phone. You know, we went through some stuff of the Bible.
Yeah.
Every time she go to church, I call her to see what they want to talk about, so I could read it with her too. So while you're studying, or we're studying about Romans, this, or Genesis, and I go to the chapter and we talk about it, what I learned or what I read, and she said, "Oh, you're doing good," and she encouraged me a lot.
Were you with her when you committed this offense?
No, man. I was with another lady,
Mm-hmm. Okay.
but it didn't work
Are you
out.
mentoring younger guys in the prison, sir?
Whenever I get a chance to, I do so. Even on my commercial cleaning class, they got some kids from the true unit, and I try to tell them stay focused, or stop talking in the class, or study for this test, because it's only one time that you're gonna get it, or after this you move to something better. Every door gonna
Wait,
open
I'm
for you.
confused. You took a class, when you were in Cheshire?
Yes, I'm currently in a commercial cleaning class, and they also got students that they part of the true unit. So we see when I go to church, I see young kids and I talk to them about Christ, about how they're doing the time, what they're doing to better themselves. I encourage them to go to the true unit, because they're on the age, so that's the best program for them. So take advantage of that program, because like that you could be ready when you go home. They teach you so many things, and I tell them what I went through, and they say, "I don't know how you have managed." So you gotta stay positive. You gotta stay
Well,
positive.
yeah, you've certainly been through a lot and you've seen it all. So I'm sure you can relate to any of these kids, right? And I understand you were in a gang when you were younger too, right?
That was my struggle the first couple of years on my incarceration. I got into a couple of fights, trying to stay away from people, and there was some time that I had no choice but to defend myself, because I didn't want to be part of that no more. That was the worst mistake that I ever did, being part of something that I know that after a while it promotes violence and negative activity, and I didn't want to be part of that. The friend telling me that this is a family we do help each other out to do better, to have lawyers and teachers, and that was so tough, and then when I went home, I said, I don't want to be part of this no more. And that was the people that I used to look up to when I was out there first. But I left all that alone, and I found myself by myself. I said, I don't need nobody. I want to be by myself, because I don't want to be part of no negative activity or sell drugs here or go rob people or beat up this person. I didn't want to be that. I didn't want to have in my life. But it was harder for me, because at that time my mother had left to Puerto Rico already. I know my family was no longer in Connecticut. And the one person that I really wanted to be with in my life was my son's mother, and she had left to Florida. So that crushed me more, and I felt lost, really lost.
Mm-hmm. Okay. Are you one of the elders in the honor program?
One of them. There's like 3 people older than me in the unit. But we all help each other, even the young kids. Even we learn stuff even from the younger guys too, though.
Yeah.
They got kids that are crafty. They have kids that are the artists. They're real talented.
Yeah.
They could do the artwork. I don't know.
Yeah.
I heard some of you from the Parole Board and Commutation went to visit us. I wasn't there. I was in school.
We did visit the program. Yeah.
You saw some of the artwork in the unit, and that was from an inmate that's in there.
Very impressive. It's unbelievable. Yeah. Good stuff. Are you still going to mental health groups?
Yes, every Thursday.
Okay. And church? How often do you go to church service?
Twice a week.
Twice a week. Okay. All right. Well, I mean, it's certainly clear that you have changed, Mr. Ramos. Definitely. How could you not, right? You were headed on a path of disaster, but I certainly see the change. Thank you for speaking with me, sir. I'm going to turn it over to my colleague, Ms. Berry.
Thank you, Madam Chair. So, Mr. Ramos, many of the questions that I had were asked previously, but I just want to follow up on a few things. For
Yes, ma'am.
clarification purposes. So the premise of your asking for this commutation is because your mental health or your substance abuse were not taken into consideration during your prior sentencing. Is that right?
Yes, that's correct.
And so we spoke a little bit about your substance abuse treatment in the past. So I wanted to know a little bit more about your mental health treatment in the past. So prior to your committing this crime, were you actively participating in any kind of treatment?
I was taking medication there. I was taking several type of medication through the years. But
So why was it
right
not
now,
working?
no, they kept trying to figure out something that will help me deal with my situation at the moment. So right now, they're giving me Cetara.
Don't tell me what kind, because this is being live streamed, so we don't want
Yeah.
everyone to be all up in your business. So
It's okay.
no,
I'm proud of
and
myself right now.
well, you should be, because you've come a very long way. So I commend you on your efforts towards your rehabilitation. A lot of people in your situation may have given up hope, but it sounds as if you persevered and you really tried to be a positive person despite your current situation. So I just want to go back to my original line of questioning, which is so if they were trying to figure out everything for you to get you on a good regimen that worked for you. Do you believe that was compromised by your continued drug use?
Honestly, it's hard to tell because every time I see the mental health doctor, I try to tell him what I was going through, and we was trying to find out how he could assist me with something that I could cope with on a daily basis, though.
Right, but you wouldn't be able to, but that's there. And now that is you in an environment where you are clean and sober. But I'm saying when you were out in the community and they were trying to figure out what medications would work for you, you were compromising all of that medication by constantly using illegal substances.
Of course, I would be better. I wouldn't have no need. I would have somebody to go to every time I have a problem with mentally or emotionally. I need somebody that I can. No.
I apologize for interrupting you. So they weren't trying to really address the underlying issues. They were trying to medicate the situation, figure out some medication, not help you work through it. Is that what you're saying?
No, they was helping me through it too. But out there, if I were to have somebody, a sponsor or a counselor for mental health, I would have never been on this drug rampage, that substance abuse. I would be better. I would be functioning without no problem.
Yeah, I think I'm grappling with the fact that you were actively participating in treatment and you were still using substances. So I'm trying to figure out if the gang membership had anything to do with your crime spree.
No, living that had me stressed out because I didn't know how to deal with that on my own, like being away from that,
How long have you been out of the gang now?
Since '96, since I was out there. When I went out there, I stopped being around other stuff. That's why it led me to my behavior.
So this is why you were committing these string of robberies in addition to your underlying stuff that we're discussing today. So the gang membership did have something to do with it.
No, I was trying to stay away from all that. I didn't want to be part of that no more. And being with them, it would have got worse. Being in that negative activity, I would have got worse. I would have been there or end up with a longer sentence or with an overdose. I'm glad I opened my eyes, but not sooner, but I opened my eyes and that life is wasn't for me.
Yeah. I mean, it's just unfortunate because it sounds like there were some tools there available to you, and it sounds as if you were making more sound decisions in certain situations, but when it came down to your substance abuse and your mental health, it's kind of that piece kind of got trampled over, I'll say.
Drugs are very
so-
yes.
Yeah. So,
Please.
my colleague spoke to you about your committing the crimes and the impact that your crimes had on the community. And oftentimes when we speak to people who commit crimes that are like yours, where they go into these gas stations and, you know, innocent people are there working, probably making minimum wage. They always seem to be a target for easy money. So you having a child now, but I mean, if he said that I want to go and work at a gas station, what would you say? Like,
What would I say? Be alert and always try to read people's body movement, you know, how they talk to you, how they react when they come in, you know, always be
would you want
attentive.
him? Would you want him to
No.
work at a gas station? Yeah, exactly. That's the point that I'm trying to make. Like, it's because of these kinds of crimes that,
Yes.
you know, people don't want their children, or adults don't want to work there, but somebody has to do that job. You know, somebody
Yes.
has to do it. And I'm glad to hear you acknowledge that you wouldn't want him to do it, because it is dangerous.
It's rough life, yeah, it is bad.
Yeah, it is. So that's another one of the impacts that your actions have on our communities, is the connection there. I see that you filed your habeas in 2019, is that right?
Yes.
Okay. And you did that on your own fruition? You didn't hire an attorney?
No, I did it on my own and with the assistance of one of my friends that know a little bit about the law, and I filling out applications. A fellow inmate.
And how did you feel when? I'm sorry, I
Was it 2019?
I thought that's what I thought I heard, 2019.
Okay, I wrote down wrong. I thought it was 2014. Or I can't read my own.
No,
Oh, there were multiple. Okay.
Anyway, so how did you feel when the judge said to you, while I regret that this may have been overlooked, there's really no merit to change your sentence? How do you feel about that?
So bad, because I thought that they really ignoring the fact that it sits in front of them, though, you know, like why they don't want to acknowledge that what they did was I couldn't get the proper psychiatric evaluation, and based on that, probably I would have got another sentence, probably not the one that I have now, and they would have addressed my mental health issues better too. Probably refer me to somebody while I was incarcerated or out there. God knows, only God knows what would have happened, you know?
Yeah. So with that being said, what do you think is, a comparable sentence for your crime, and using your with your mental health and substance abuse? What do you think is appropriate?
Well, right now I thought, wow, this is pretty much all my life for right now in jail. But I'm working with my mental health treatment, though, you know. My drug addiction problem that I had, I still went to programs, and that's something that I could do out there in the community to help myself. I could help other people from stopping using drugs. I could let them know about my experience, what I have went through, you know, how would that be better for them, you know? And
So you think that you'd be an asset in the community? You think that you could help other people better out in the community?
Yes, I also want to work with outreach program, though, like Mrs. Wasilewski in New Haven. I know that. I know they also have some place in Hartford that they connected to them. I could work with the youth out there. There's a lot of kids out there that they need guidance, and a lot of people don't understand their behavior. You know how to approach them. You know, they see police and all they want to see, they look at them like the enemy. You know, or here comes the cop, but they don't know that they there to help and protect. That's what they're doing in the community. You know, they know if you're doing something wrong, of course they're gonna take action and try to take you out of the way to so and let the law, you know. But that's what I want people to see what's being done to their life, though, you know, and not only their life, but the damage that they're doing to the community, you know,
Right,
putting
exactly.
fear.
Yeah,
I,
it
I
is.
like I like to see I like to see people and kids walking with their pad on the street without fear about somebody getting shot or
We would
finding
all
something
like
on
to
the
see
property.
that. We would all like to see that. But unfortunately, these things like this keep lots of people employed because, the crime is just rampant. So it is. I'm glad to hear the insight that you've gained, Mr. Ramos, and I really do hope that you are able to continue sharing with the other people that are in there and that you continue to grow. And I'm glad to see that you're addressing your substance abuse problem and your mental health issues. So I appreciate our discussion. Thank you, Madam Chair.
Thank you. Can I ask you, sir, to tell us about your involvement with the Douglas Project?
Yeah, there were some people from, I forgot what college they came from, but the first time they have people from parole, probation officers, some people that came from New York, some outreach program that they had there before. But this time they have people from college, some college kids and the teachers. It was a good experience though, you know, because
What did you do?
they want us. We built with them, we sat down, we explained to them what we're doing here, what some people are doing just to better themselves. Some people choose not to get help because of their pride. You know, the pride is just knowing but drawing you back to the person that you was bad, though, you know. Pride is not good. That's the opposite of being acknowledged of what you want to do. Be proud of accomplishing a lot of stuff. So and a lot of them kids empathize with the things that we went through here, we're going through in here. And I saw the motivation and they're willing to learn more about us and how can they help us. And it was a good experience that I would like to share some other time, even out there through some outreach program or something though, you know. I like to get involved with things like that. That helped me feel good.
You've been working throughout your incarceration, right?
Yes, ma'am.
Yeah, I mean, you had excellent evaluations for your work as chairman, in the kitchen, the showers, you know, and all your programs too. You had excellent evaluation. You took a lot of programs and vocational education. What was your favorite type of work?
I know, even though I cleaned the showers for almost 5 years, you know, sometimes they'll be filthy with feces or people be throwing stuff on the floor, throwing up because or whatever they ate or if they have something, you know. I had to clean that, but I learned to adapt because it's a work. Somebody had to do it, you know. But I took pride in what I did for the past 5 years. So
I agree with you. Who wants to clean a bathroom, right? But I love a clean, when I clean my shower, my toilets, my sinks, I love to sit back and look at a clean bathroom. So I can see how you take pride in that for sure, Mr. Ramos. Yeah. I appreciate that.
I have to tell people, listen, I'm doing this for everybody, so everybody could have a decent shower though. Be mindful who's going to be taking a shower next. You don't want to go in the shower and see a lot of snot on the board because people blow their nose inside the showers or pissing in the shower. You know, be mindful of the next person, you know.
Right.
And I try to put that in their head little by little, and little by little they started listening. And I started seeing less garbage, and they be respectful more to their peers, and that made me feel good because they taking notice of what was going on, though, you know.
Yeah.
They appreciate what I was doing.
Definitely. I'll note for the record that we had a lot of support letters for you from other inmates, from your family members, from correctional staff, from the chaplain, from people who came before us in commutation hearings. So you have a lot of support there, and people really do think highly of you inside the prison. So just want to put that on the record, and the excellent evaluations. Okay, I think we're done with our questions, sir. Do you think you've said everything you want to say to us?
Yes, I know I'm going to be, I know if granted the opportunity to to be on back into the community, probably to a halfway house or something. My son, I can't wait to. I would love to work with my son and where he work at. He got his own company doing roofing and stuff like that. But
Yeah,
my goal is to
Windows,
have my
we
own
heard
little
about that.
company with him. My goal is to have my own company with him, my own cleaning company.
yeah, it's a nice
That's what
goal. I like that.
Thank you.
Okay, we've confirmed with the Office of Victim Services that we have no input for today's purposes. So at this time, we will ask for the state's attorney's office to weigh in. Attorney Walcott, thank you.
Thank you, Madam Chair. And I do apologize for being tardy to the start of the proceedings. I had a little bit of trouble logging in this morning, so I do apologize for delaying the board in this hearing, and just appreciate the time. I did send in a letter for this hearing, and I will be fairly brief. There's just a few things that I wanted to address before the commission members. And notably, just starting with Attorney Tubbs' statement, the job of a prosecutor is not to say that the original sentence is correct. And I've attended a lot of these commutation hearings, and I attend each one listening in intently to the statements that are made, to the questions by the board, to the statements from the attorneys. I value the commutation process and everything that this board does, and reviewing the packets, looking through and seeing what our file has and seeing what changes there are. And throughout the process, or in my review, I'm always looking for where's that extraordinary piece. And then logging in to listen, I'm listening for where's that extraordinary change? Where is that rehabilitation that surpasses just time spent in a facility? The hope is that every incarcerated individual grows in some way, just by sometimes just by the passage of time. But in the case of Mr. Ramos, where he's picked up employment, he has new skill sets, he has certifications, there's jobs that he's doing, he's leaning into his rehabilitation. And with the programs that he's done over the last few years, he's starting to lean in. I do still have pause though, and I pause with the nature of the crimes. Those 4 robberies, he committed 2 robberies, the third one ended in a homicide, and then he went back out and repeated a robbery, another gas station attendant who he assaults with the firearm that supposedly, accidentally went off in the third incident, but he repeats that exact same pattern. And even following the homicide, he goes back to the car where he meets up with Frederick Wright, who has had his own struggles, meets up with him, kind of brushes his hands off, splits the money, and goes out and continues to purchase narcotics. There's just a lack of a recognition of what just happened and to repeat that crime. So I do struggle with the sequence of the crimes. But then when I look at the packet that's submitted in Mr. Ramos's program history, I continue to struggle with the lack of a substantial period of rehabilitation. He has a ticket as recently as 2018. We're here at a hearing in 2025. There's not that what I expected or hoped to see was a period of at least 10 years. We've had individuals apply for a commutation where they've gone 20, 25, 28 years with no ticket. And so Mr. Ramos sits here and just as recently as 2018, received a ticket for fighting, prior tickets for incarceration, trying to bring drugs into the facility. Again, just repeating the same issues, the same errors, the same behavior. So at this point, I would object to his commutation package, not because he hasn't changed and what he's doing is commendable. It is. It's just not extraordinary. Extraordinary to the point where it rises to the level of commutations that this board has granted, and quite frankly, commutations in the past that I have stood behind someone and said, they present very well in what they're doing. So I thank the board for the time. Mr. Ramos, thank you for your presentation. And then for the record, first name Sharmise, last name Walcott, and juris number 423818. Thank you.
Thank you, Attorney Walcott. Okay, Mr. Ramos, at this time, we will enter into deliberation to discuss your case amongst ourselves. Of course, everyone's free to listen, and we'll come back to with our decision shortly, okay?
Thank you.
Mr. Sitez, yes.
Thank you, Madam Chair. So
Yes. Thank you.
So Mr. Ramos came today and sounded good. He expressed remorse and apologized, taking responsibility for his actions. He's taken lots of positive programs and has worked throughout his incarceration. And over the last 8 years, I can see that he's clearly made some positive changes in his life. Takes pride in his work, as he talked about. Said he's proud of himself, and I think he should be. He has gone out of his way to help others, young people in the facility. But when I look at the first, 22 years of his incarceration, we're almost at 30 years now. He agreed that his first 22 years, where he received 22 disciplinary reports, was not an exceptional period of time for him. And regarding this mistake in his medical records, at the time of the sentencing, Mr. Ramos indicated in his application, and he spoke again about today, the issue has already been reviewed, determined by the court that it did not warrant reopening his sentencing. And I didn't hear anything today that would make me feel otherwise. So based on everything I've read and all that we've learned today, I see that over the last 8 years, Mr. Ramos has changed and is doing well. However, do not feel that it rises to the level of compelling and exceptional circumstances that would warrant commutation from me today.
Thank you. Okay, so I see things a little bit differently. I mean, I agree with much of what you said. I just went back and looked at his tickets in the system quickly, and 15 of the 22 were in the first 3 years, and the other 7 have been spread throughout the remaining 20, 7 years, 26, 27 years. When I look at Mr. Ramos's history, yeah, he was 26 when he committed this offense, but I think his mentality was more of like a teenager. At the time, he was not living a productive adult life. He had little support, and he was in the streets, acting like someone much younger. And I do believe that he was in an altered state of mind. I mean, to do some of these things, you would have to be, I suppose, but I think he was severely affected by mental health and addiction, which oftentimes go hand in hand because of the trauma that he experienced in his childhood, in his youth. Speaking to him today, it's like I see a completely different person than the person that you read about on paper. He's doing such great work, and he's recognized by everyone around him for all of the positive things that he's involved in. And there are times we see this on paper, but I'm not convinced. There are times I come in here and I'm thinking, well, yeah, we're doing all these programs. We're doing these programs because we want to get out, right? And we know what the parole board wants to see. In his case, I really do find it genuine. I think I think he really does want to give back and do the right thing. I think his remorse is genuine, and I think his transformation and rehabilitation is exceptional, in my opinion. So I would be willing to commute a portion. I'm not saying I would totally commute his sentence today, but I would certainly grant a commutation of a portion of his sentence here today. Ms. Berry.
I think that my position was more along the lines of Mr. Sazowskis. I really did struggle with the substance abuse and prescription med cocktail, and the repeatedness of these type of crimes where, I mean, I know that the robberies really are not, he's not asking for those, but they still, every single one of them had victims every single time. He hit them in the head. Some people had to go to the hospital or receive stitches. Like, it was just, menacing. And I think that maybe his son being an active part of his life really may have also added to his really wanting to change and wanting to be a better father and honestly wants and I guess spilling over into the facility and wanting to be that kind of figure that he didn't have to other people inside the prison, you know? I was impressed with his responses, and even when I asked him about what he thought his sentence would be, he didn't. I recognize that he didn't answer it, but he said, "I think I would be more of an asset out in the community," and that's that's admirable, in my opinion, because I would have said I need to go home, and that's just me. But I just appreciate his sincerity and his genuineness and wanting to give back. And I think that his relationship with God just amplifies things as well. Like those beliefs that, you have to, be a better person. So again, I came in thinking along the lines of Mr. Sazowskis, but I mean, honestly, I don't really, by the time that he's done with his sentence, I think he'll be 77 years old. That's still fairly young in this day and age. So I'm not really sure what you're willing to do in terms of commuting a sentence.
Okay, so you're willing to entertain a commutation, is what you're
I'm
saying?
willing to entertain,
Okay,
I guess. I'm willing. I want to hear what you think is
okay. Well,
reasonable.
yeah, I mean, I really don't see 77 years old as young. I wake up every day and I don't feel young
I
anymore.
know, but I mean, in this day and age,
No, I understand. It's not a death sentence, I
Right.
think is what you mean to say, but 10 years? I mean, what are your thoughts?
I was at 5. That's what I was willing to entertain. And I know that
I think
really
a fifth of his sentence is more than reasonable. I mean, 5 years isn't going to have much of an impact, I'm not sure.
yeah. That's where I was. So 10 years would be 36.
I'm sorry?
10 years would bring his release date down to.
Oh, right. I mean, I was just looking, that brings us to a 40-year sentence. It's still a very lengthy sentence. Yeah. His release, right. It's 46. He's not earning any time off. He's not earning any rec time.
Mhm.
He's not eligible for any good time of any kind.
He's been down for 30, and that would be 40 years. Okay.
Yeah, no, he's doing all of his time. Yeah.
Okay. I would be willing to do 40 years.
Okay. All right. In the matter of Julio Ramos. Entry number 163865. I'll make a motion to commute his felony murder sentence from 50 years to 40 years, commuting 10 years from his sentence. Is there a second?
There is.
All in favor?
I.
Aye. Opposed?
Okay.
Okay, it's a majority decision with board member Sazowskis dissenting. Mr. Ramos, do you understand what we did here, sir?
Yes, ma'am.
Okay. Keep working on yourself and keep giving back, okay? We wish you the best. Thank you, everyone, for your participation.
Thank you.
Thank you.
Jesus Christ.
Now concludes the December 17th, 2025 commutation session of the Board of Pardons and Paroles for inmate Julio Ramos, number 163865. Time is now 10:38.
Where's my,
Morning, Parole Officer Vasquez. Today's Wednesday, the 17th of December, 2025. This is a regularly scheduled State of Connecticut Board of Pardons and Paroles of Passionate Parole Review. And we have the chairperson who's going to say a few words about this.
Thank you. Okay, so we were supposed to review Mr. Williams, MA number 302204 for compassionate parole today. However, we received email correspondence from Dr. Johnny Wright, who's a medical director with the Department of Correction, asking to formally rescind and withdraw his previously submitted request for compassionate release. So apparently the offender's condition has improved and he no longer meets the requirements for compassionate parole. So in this case, we have nothing to hear. So we will be canceling this compassionate parole review scheduled for today. Thank you.
Going off the record.
Good morning. I'm just gonna give Saunders 5 minutes to see if they connect. If they don't, then we'll move forward.
All right, Caitlin, can you hear me?
Yes, I can hear you
Okay,
now.
I showed I was muted and then I asked you, and you didn't respond. You can hear me now?
Yes, now I can.
Okay, perfect. Thank you.
Okay. Good morning, P.O. Saunders. Can you hear me?
Hi, good morning. Yes, I can.
Good morning. All right, we're gonna get started with the hearing. Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning Bruno Mercedes number 419-034. Today is December 17, 2025. This hearing is being conducted via video at the BOPP Central Office in York Correctional Institution. This is a public hearing, and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Mercedes Bruno 419034.
And you have parole officer present today. Can you please identify yourself for the record?
Parole Officer Saunders with the Women's Reentry Unit.
And we have counsel here today. Can you please identify yourself?
Sure, Attorney Alfonso Sirica with the Parole Revocation Unit on behalf of Ms. Bruno.
This is a revocation hearing to determine whether you have conditions of your release. You make findings of fact as each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your paroles and release you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state and parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present all relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, you have important rights today. You have right to have an attorney present. You have counsel here. You have a right to receive the written notice, charges of violation. Did you receive the written notice?
Yes.
Okay, you have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
All right, so we now review the charge the state or parole officers bring against you and the information underlying each charge. So P.O. Saunders, will you please read the charges? You do not need to read charge 2 as a no finding was made at the time of the prelim. And as well as part 2 on charge 1, which is the 9/11 date, no finding was made on that, so you do not need to read that as well.
Okay. Okay. Charge 1, drug testing. On 9/3/25, you were instructed by MCCA staff to provide a toxicology screen. You refused to submit to the drug screen via urine analysis or mouth swab as instructed. Charge 3, obedience to the law. On 1/31/25, you started your term of probation as part of a criminal sentence you received on 7/12/22. On 11/26/24 to 2025 and 6/12/25, you reviewed and signed your standard and special conditions of probation, indicating you understood and would abide by. Your special stipulations included substance abuse evaluation and treatment, mental health evaluation and treatment, any other treatment deemed appropriate, verifiable restitution, 100 hours of community service, the ignition interlock, and no driving unless licensed. On 11/27/24, the Office of Adult Probation determined that pursuant to Public Act 23-53, you met the qualifications as a serious firearm offender. You were explained that the full compliance is required to avoid violation of probation and that any noncompliance would result in a VOP arrest warrant. On 5/1/25, you completed an evaluation with Connecticut Counseling Center and recommended to attend women's co-occurring IOP and also rendered a positive test for PCP. On 5/5/25, you reported to your probation officer that you were traumatized by Connecticut counseling and did not want to return. You were advised that you would be discharged and referred to MCCA. On 5/21/25, you attended your evaluation at MCCA and recommended to engage in cognitive behavioral therapy. On 6/5/25, 6/19/25, 6/26/25, and 8/7/25, you failed to attend your CBT group and received unexcused absences. On 9/3/25, you failed to render MCCA. On 9/4/25, you attended MCCA for a psychiatric evaluation with an APRN and you denied medication assistance. On this day, you rendered a mouth swab with parole, which resulted positive for PCP. Your behavior while at parole was combative and disruptive, and it was determined that you would benefit from inpatient treatment. On 9/8/25, MCCA recommended inpatient treatment and advised parole would make the referral. You denied at this time. On 9/9/25, you were unsuccessfully discharged from MCCA due to program noncompliance, excessive missed sessions, denied medication management, and failure to render toxicology screen upon request. For these reasons, it was found that you violated condition number 8, take part in any risk needs, medical or behavioral health evaluations or treatment, substance abuse testing, and any other treatment services that the court or your probation officer requests. On 10/1/25, a GA2 judge signed a warrant for your arrest for violating Connecticut General Statute 53A32, violation of probation. On 10/15, a GA2 judge found probable cause under docket ending in 814 and motor vehicle docket ending in 56 and provided you a next court date of 11/7/25. Charge number 4, drugs. On 9/11/25, while at Foundation, you rendered a positive urine screen for PCP. On 9/17/25, the lab confirmed the presence of PCP. On 9/4/25, you rendered a positive mouth swab for PCP. On 9/28, Premier Biotech returned a positive specimen for PCP. On 5/1/25, while at Connecticut Counseling, you rendered a positive urine analysis for PCP. On 4/9/25, you rendered a positive urine screen for PCP. On 4/16/25, Premier Biotech returned a positive specimen for PCP. Additional conditions, charge number 5, mental health evaluation and treatment deemed necessary. On 5/1/25, you attended a mental health substance abuse evaluation at Connecticut Counseling Center and treatment was deemed necessary. You were recommended to the Women's Co-occurring Mental Health IOP group meeting 3 times a week with a start date of 5/5/25. On 5/5/25, you were discharged from this group at this program at your request. On 9/5/25, you attended a psychiatric evaluation with MCCA. As a result of the evaluation, you were recommended for medication management related to mental health and addiction. You denied this recommendation.
Thank you.
You're welcome.
And can you please read, or for that, I did want to note that on charge 3, CBT group was not taken into consideration. No finding was made at that in regards to obedience to law charge. Can you please read the addendum that was submitted?
Sorry, didn't have
Okay.
that.
you don't have it up, I can read it.
Yes, I don't have that.
Okay,
I
so
don't have
we
that.
did receive the addendum from PCS, and the addendum did note on 11/17/25 regarding this docket 814-S case was disposed of and probation continued on 11/17/25 docket ending in 356. This case was disposed of and probation was continued, so there's no pending further charges at this time. The state did follow the following exhibits that were marked at the time of the preliminary hearing, which were exhibits, state exhibits A through O. These were noted as received by council. Is that correct?
Yes, that's correct. And I stipulate to what, you don't need to be reading them again.
And council has filed the following exhibits that are pre-marked for identification. Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay, we have no witnesses today. At this time, I am going to swear in Mrs. Bruno as well as P.O. Saunders in the event you would like to speak today. So can you both please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes.
Yeah.
Okay, thank you. So at this time, the state is going to have an opportunity if they'd like to present evidence and speak to any of the evidence submitted. So would you like to speak at this time?
I think everything's pretty straightforward. There's nothing else.
So we'll go to defense, if you'd like to speak to any of the evidence submitted at this time.
Yes, just briefly, we did conduct a preliminary hearing on October 31st of 2025. And the majority of my argument at that hearing was to do with the obedience to the law charge that was the basis of her probation violation. All those violations predate her successful completion at the APT Foundation. So I did provide her attorney in court with the documentation, the certifications of her completing that program, thus the disposition from court where they allowed for her to continue on her probation. And just one quick question for P.O. Saunders. Is that a fair statement of what I just put on the record, that the basis of the obedience to the law, the violation of probation, those violations predate her completion of treatment? Is that a fair statement?
Yeah, they do. But at that point, she was already in violation of her probation. So
Correct.
because she's on dual supervision, I proceeded to do what I felt would be the next step.
Correct. Yep. And I'm not disputing that. And as a matter of fact, I know you did not participate in the preliminary hearing. She was at the APT Foundation, I believe, when the warrant for the violation of probation came out. She was allowed to stay there and complete that program on October 15th of 2025.
Yeah, because probation wouldn't have picked her up. Correct.
And then I believe you brought her to probation to have the warrant served. Correct?
Yeah.
Okay.
Yep.
All right. I don't have anything else to add regarding the first part of the hearing. As I indicated today in the preliminary hearings, at the preliminary hearing, I did provide to the hearing examiner the certification of achievement from the CBT group that she completed in August of 2025. Also, the APT Foundation that she completed on October 14th, 2025. And then the next day she was brought to probation and had that warrant served. And also the certification of completion of the Sharon Victims to Stories. She did complete her victim impact panel also. So I understand that those violations were part of the probation violation, but since her treatment, she has completed the treatment that was needed for her to stay on probation successfully. And it did indicate in the parole violation report that P.O. Saunders submitted. She did complete CBT group with MCCA in 8/13/25. 9/11, she admitted to the APT, successfully discharged on 10/14. While at the APT, she completed additional psych evaluation, met with a PRN. She re-engaged with medication management, referred engaged in community service with Interfaith Ministries, completing 32 of her required 100 hours. And as I indicated, she completed the Mothers Against Drug Driving Impact Panel. So she has completed now, I know it's a bit late, but what she was supposed to do on probation. And I believe that's why they allowed her to admit she violated probation and continue on her probation. And obviously she's going to be on dual supervision once again, because I'm showing her sentence date for the parole supervision is not until next year, December of 2026. Thank you.
Thank you. So I'll be right with you with my findings. All right, so regarding charge 1, as I stated, the 9/11 date was not taken into consideration. Regarding the 9/3/25 date, I do find you violated that condition drug testing based on evidence that was provided in support of that charge, which is exhibits A and G. Charge 2 was not taken into consideration as no finding was made at the time of the prelim and no new evidence was submitted by the state. Regarding charge 3, I do find you violated that conditional obedience to the law based on the evidence that was provided in support of that charge, which is exhibits A, E, and F. As I stated, CBT group was not taken into consideration as no finding was made at the time of the prelim. Regarding charge 4, I do make a finding that you violated that condition drugs based on evidence provided, which is exhibits A, G, H, I, and K. Regarding charge 5, separated this into 2 parts. Part 1 is 5/1/25. Part 2 is 9/5/25. I make a finding on part 1 on mental health evaluation based on exhibits A, K, M, and L, and I do not make a finding on part 2 chart on the date 9/5/25 as the offender re-engaged with medication management prior to 10/14/25 while at that foundation. So there is no finding on that date. That includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So at this time, P.O. Saunders, would you like to say anything for this part of the hearing?
I would just say that this is Mercedes' second violation for this special parole term. It was kind of hard getting down to her past history due to like computer issues. But once it was discovered that there were some other previous concerns, I think it's important that Mercedes remains engaged with medication management. Otherwise, she did a really good job. She needs a lot of encouragement, but she did a really good job trying to move forward. I would just, again, she needs a lot of support. And I think in this area where I was supervising her, the supports were rolling in, but unfortunately, other things were playing out in the background. So as she can keep that in mind, she will successfully complete her special parole term and her probation term.
Thank you for your statements. So now I'm going to turn over to counsel if you'd like to make any statements regarding the offender's violation background or history at this time.
Yes, on behalf of Ms. Bruno, I am asking you to take in consideration that she did complete that app foundation, as I previously indicated. I know it was after the fact, after the violation of probation came up, but she did engage, she did complete it, and as P.L. Saunders put on the record, after she completed that program, she engaged in additional services. My client, she does have 2 children, age 18 and 15. She did report to us her 18-year-old son joined the Marine Corps and is scheduled to begin boot camp in June of 2026. She has good support group from Florida. She was raised in Florida, and she has 4 sisters who live in Florida, an uncle and various cousins who she's still in contact with. As far as where she was housed, it looks like upon her release in January of 2025 to March, she did successfully complete the Community Solutions Halfway House program, the Silliman House in Hartford, and then she was at the Connection Reentry Assisted Community Reach in Waterbury. And she is planning on obtaining her OSHA 30 certification with the help of Project Longevity. She did actively searched for work. She's indicated she did submit numerous applications with the help of Project Longevity, and she did have an interview scheduled with Amazon in Windsor just prior to her remand. Her last job prior to incarceration, she was working as a flagger. As I indicate, she did complete an intake at Connecticut counseling, and then they requested a transfer to Midwestern Connecticut Council on Alcoholism. May 2025 to September, did participate in clinical services at Midwestern Connecticut MCCA in Waterbury. As I indicated, she has completed treatment, and then she also did follow up with what her parole officer asked her to do. She did indicate to us, as far as community services, she did volunteer at the Greater Waterbury Interfaith Soup Kitchen in Waterbury with the help of Project Longevity. She was obviously in contact with her parole officer. None of the violations have to do with her reporting, and she's on dual supervision, as we already discussed. As far as housing upon her reinstatement, she has discussed being placed at the Connection Reentry, the Reach in Bristol with parole. That's what she indicated to us. And ultimately, at some point, either she finishes her supervision or needs to stay in compliance. She'd like to get back to Florida to be near her sisters. She does want to complete the Stay Approved training program to become a certified nurse's aide. She enjoys taking care of people, and she does want to obtain that OSHA 30 certification. Mercedes, anything I left out regarding your background or what you want to do when you get out? If you want to add anything you feel I missed off this report, copy of the report was given to the hearing examiner and to P.O. Saunders. And if I just may add one thing, I have neglected to start with that. P.O. Saunders, I appreciate even at the preliminary hearing, you reaching out and actually participating in Ms. Bruno's well-being. So I know you did reach out to me and you had indicated, unfortunately she was violated because of her probation, but since she did complete the treatment. So I appreciate you letting me know all that. I don't have anything else to add.
Okay.
Like I said, I know P.O. Saunders put on the record, this is her second violation. We are not disputing that. She's been incarcerated since October of this year. She did complete the treatment. I am asking her to have her reinstated as soon as possible. I think it took her a bit, but she did get back on track. And there's still a year that she needs to stay on supervision where her parole officer, she needs to comply. Otherwise, she's going to be remanded again. I think after sitting for a while, she has everything in order. Thank you.
Thank you. P.O. Saunders, does the offender have a bed at Reach, or does she need halfway house placement? Might be frozen.
Yeah, it looks like her screen is frozen.
Yeah, it definitely is. All right, so usually we don't place in Reach beds. Well, we can't place in Reach beds. So if you have to go to a halfway house prior to that, if your offer does have a bed, you can obviously go to there. But if you have to go to a halfway house region, what area would you want to go to?
New Haven.
Okay. I don't know if P.O. Saunders can maybe restart. I'm going to pause the record for a second. I just want to see if we can get her back before. I'm just going to redial her to bring her back in. While we're waiting for her, I'm going to review before I make my recommendation, and I'll let you guys know when she gets back. All right, well, we're back on the record. I'm just gonna put a few things on the record. After reviewing all of the evidence, that was submitted, defender was in the community about 8.5 months before her return to custody. As we previously noted, on 11/17/25, probation was continued. There's no pending charges, or anything open. There's a prior criminal violation in which the defender was auto revoked on this period of supervision. Just have 3 misconducts that were received. And Saunders is coming back, so that's good. You are in special parole supervision until December of 2026.
Sorry about that. My computer.
No, it's okay. I'm just making sure that I was waiting for you to get back before we finished up.
Thank you.
Is there anything else from any side before I make a recommendation?
No, I
I
don't
did-
have anything else to.
I did hear
Go
a
ahead, yes,
question. Yeah, she'll, right now the reach beds are full, so she will need a halfway house.
Okay, thank you very much. That's awesome.
You're welcome.
Right, so, and I will note the, PCS recommendation was, to follow the court's recommendation. Based on all the information that I have, I am, as well as no findings that were made, I am going to recommend that parole be revoked to be re-paroled for February 13th of 2026, about a 4-month period confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, operation of motor vehicle, and mental health evaluation and treatment deemed necessary. My findings go into the parole board on December 31st. You will receive official written decision from the board about a week after December 31st. The board can lessen that sanction. They can let it stand or impose a sanction longer than what I've recommended. If the board decides to impose a longer sanction than what I've recommended, you have a supplemental hearing. And before the hearing, the board will provide you with written notice documenting the reasons why they may want to exceed my recommendation. During the supplemental hearing, you would have an opportunity to respond to those reasons while in front of the panel of the board. So just so you know, those are the options on December 31st. You will, as I said, receive that in writing from the parole board, what their decision is a week after sometime of December 31st. Do you have any questions?
I don't.
Okay, just want to add, so Mercedes, if there's an issue with them adopting that recommendation, I'll set up a call with you to explain to you what the next step is. Hopefully we don't have to do that, but that is one of the possibilities, okay? And also want you to know you are on discretionary parole, which is different than special parole. Even if the board adopts the recommendation, that February 13th date is on or after date. So even if they adopt it, you might not get out exactly on the 13th. We just got a parole officer has to line everything up for you. If you were on special parole, then they would have to release you on that date. But so it's on or after date. Just keep that in mind, okay?
Okay, and the earliest date you could be released by the board is December 31st. So that's a possibility as well, anytime in between. Okay? All right, so you're all set.
All right,
That's
good
the
luck to you.
conclusion of the hearing.
Thank you.
Thank you.
Thank you, Saunders.
Thank you.
Thank you. Good morning.
Hi, good morning.
Is Rice there yet?
All of them are here.
Can I see Rice, please?
Okay. And then you want to go down the list after that?
I need, can I see Corona after that?
Okay.
And then I'll just go down the rest, Hathaway, Torres.
Okay. All right.
Thank you.
You're welcome. You gotta push the back.
Morning, Mr. Rice.
Right. Back that way. There we go. Give me a chair. Sit down. All right.
Sorry about that.
Good morning.
Good morning. How you doing?
Good, how are you?
I'm blessed. I woke up. Thank you.
We're gonna get started 1 second, okay?
Okay.
Don't know.
Attorney Circa, are you all set too?
Yes. Can you still hear me?
Yes.
Yes.
Okay.
Good. Good morning, I am Theo Meisinger, hearing examiner for the Board of Pardons and Paroles, revocation hearing concerning Bryce Lucky, number 218186. Today is December 17, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. This is a public hearing. Public access to hearings available via video live stream. Can you please state your full name and DOC inmate number for the record?
Lucky Rice, 218186.
You have counsel here today. Please identify yourself.
Sure. Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Rice.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact with each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, release you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will have an opportunity, state is not present today. Council will have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, council will have an opportunity to hear background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. Are you important rights today? Right to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine reverse witnesses. Do you understand these rights? Am I ready to go forward?
Yes.
Okay, so we now review the charge the state officers bring against you and information underlying each charge. I will note charge 1, program participation is not taken into consideration, as a no finding was made at the time of the preliminary hearing and no new evidence was submitted by the state. So charge 2, under release direction absconder, your charging officer report on 10/1/25, you voluntarily left your only full approved residence, fellowship, halfway house in Groton. You did not return. You made no attempts to contact the halfway house or parole, indicating you had intentions to purposely avoid parole supervision. All attempts to locate you via collateral contacts were unsuccessful. Your whereabouts community remained unknown until 10/14/25, when you were located in the city of Hartford and arrested by Hartford Police Department for criminal trespassing 2nd degree. Charge 3 in obedience to the law. Your charging officer report on 10/14/25. Hartford Police Department responded to a call to residents in Hartford due to claims of black male wearing all black, trespassing in the stairwell. Upon police arrival to the residence, they located a black male in the black stairwell of the residence, matching the description provided. You were identified as the male in the stairwell via your CTID. You do not have legal rights to be on the property, as you were neither a resident or authorized guest. Hartford Police subsequently arrested you for criminal trespass 2nd degree, and you were issued a misdemeanor summons the court date of 10/23/25. Charge 4, drugs. Charging officer reported on around 9:17 and 9:26:25, used cocaine. Charge 5 under halfway house placement. Your charging officer reported on 8/8/25, you were signed out of the Fellowship Halfway House on an approved community pass to T-Mobile and Groton to pay your cell phone bill. You were signed out from 4:54 p.m. and you returned to the halfway house at 5:20 p.m. Upon your return, you were asked to submit your receipt as proof of your whereabouts. The receipt from T-Mobile was timestamped 2:07 p.m., during which time you had been signed out on another community pass to C-Car in New London. The receipt timestamp indicates you deviated from your earlier community pass to C-Car and that you did not go to T-Mobile during the later pass from 4:54 p.m. to 5:20 p.m. You were on a call and community for approximately 26 minutes. On 9/11/25, a search of your assigned room at Fellowship Halfway House was conducted. During the search, an orange THC vape was discovered inside your nightstand. You admitted the vape belonged to you and that you had purchased it while on a community pass without authorization from the Halfway House. On 9/17/25, a search of your assigned room at Fellowship Halfway House was conducted. During the search, a THC vape pen, a box cutter, a piece of chore boy attached to a string was located amongst your property. Your actions been in violation. You signed a halfway house agreement. At 9/29/25, you were signed out on an approved community pass to attend your scheduled substance abuse group at SCAD in London. Your pass was issued from 8:30 a.m. with a scheduled return time of 1:30 p.m. On 10/1/25, SCAD reported you did not attend group on 9/29/25, claiming that you had a doctor's appointment. Fellowship Halfway House confirmed that your doctor's whereabouts was scheduled. Your doctor's appointment was scheduled for 9:30/25 at UCFS in New London. Your whereabouts committee were known on 9/29/25 from 8:30 a.m. to 1:30 p.m., approximately 5 hours. On 10/1/25, you voluntarily left your parole-approved residence Fellowship Halfway House in Groton, and you did not return. You did not have permission from the Halfway House or parole to leave the Halfway House. You're actually in violation of your signed Halfway House agreement. And the state has filed the following exhibits that were put on the record at the time of the preliminary hearing. Those were exhibits A through B, which was noted as being received and reviewed. Council, is this correct?
Yes, I will stipulate to that. Although I was not present at the preliminary hearing, we were not appointed yet. I do have copies of the evidence. I will stipulate to that evidence.
Right. And council has filed the following exhibit, pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. So it is now defense's opportunity, if you'd like to present evidence, to speak to any of the evidence submitted at this time.
Yes, just briefly, as I just indicated, there was a preliminary hearing that was conducted on October 21st of 2025 prior to our office being appointed to Mr. Rice. And he did put on the record, he's not disputing the charges here, obviously. He did put on the record that shortly after being placed back in the community, he did still had issues with drug use and messed up while in the halfway house by having vape pens. So I know Mr. Rice did put that on the record at the preliminary hearing, and that seems to be the basis of these violations. He still does struggle with substance abuse, and he's obviously trying to address that. The other charge I'd like to address is the obedience to the law. I'm not disputing that that is a criminal charge, but the facts of the case I think are important. On behalf of Mr. Rice, he was in a stairwell of an apartment where he was not supposed to be. He's not out committing a larceny, which typically drug users do, or involved in fighting with someone. He was in a stairwell of an apartment where he was not supposed to be. Thus, the criminal trespass and the disposition from court was an unconditional discharge. Shows me how serious the court thought that it was by giving him an unconditional discharge. Charge 4, as I indicated, he's not disputing that. If I may, Mr. Rice, the incident on
Well, let me
August...
just swear him in
I'm
first.
sorry.
If you,
Yes, I'm sorry. I thought
Mr.
you
Rice,
did.
I'm gonna swear you in so that you can speak today. So can you just raise your right hand, please?
Yes.
You solemnly swear, solemnly affirm, as the case to be, the evidence you shall give concerning this case to be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes, ma'am.
Okay. Go ahead.
If I may, Mr. Rice, regarding charge number 5 under halfway house placement on August 8th, regarding you being 25 minutes late, you did go out and you did return, correct, to the halfway house?
Absolutely.
But
Yes.
you were late. Could you let the
Yeah,
hearing
I was late.
examiner know why you were late that day?
Oh, okay, I had to walk, because it's like where I walk to on Long Hill Road, you gotta walk down Long Hill Road. So I came there, went back, but I told him about the paperwork. I guess the paperwork showed me I was minutes late, but I'm walking to my destination. Ain't no bus or nothing.
Okay.
But I was late. I can't. Yeah,
Right. You were late, but you did return to where you were supposed to be, correct?
Absolutely, yes.
Okay.
Yeah.
I know at the preliminary hearing, you took claim to the vape pen. The concern I have, the one on 917 where they found a vape pen, the box cutter.
That's on my job when I was working.
Correct.
Yeah, I was working at, they knew that already. They knew the box cutter came from my job, White's Furniture. I got to open up sofas and stuff. They knew it came from, I don't know why they put that in there, but they knew
and that's why we're addressing it on the record. The box cutter, you were working as a mover at the time, correct?
Yes.
And they knew what you were doing for work. Okay.
Yes.
And my last question to you is regarding the September 29, 2025, regarding the doctor's appointment. Can you let the hearing examiner know what occurred that day?
I had a doctor's appointment.
Yes.
I had a doctor's appointment. Yeah, I had a doctor's appointment, but they put down the wrong date for me at the doctor's appointment.
All right. Did you actually go to the doctor's office?
Yes.
Okay. And when you got there, you were informed that you did not have an appointment, correct?
Yeah, they had to call a lady. Yep.
Okay.
Yeah, I was informed that. Yeah, but I had the paperwork. I had the doctor's paperwork and stuff like that.
Okay. So I don't have anything else to add. My singer, I just wanted to give you a little background regarding it seems the downfall is the substance abuse problem. Obviously, he was out in the community. It looks like July 1st is when he was paroled, and he did self-admit, I believe, at the preliminary hearing also. Shortly thereafter, he started using again and he relapsed. That seems to be the basis of the downfall here. So I don't have anything else to add at this time. I would like to be heard about his background at the appropriate time.
Thank you. I'll be right with you with my findings. I did want to put on the record, as you had stated, the addendum from PCS did indicate on 11/7/25, offender was convicted of criminal trespassing second and did receive an unconditional discharge for that in court. Right. So there's no pending charge at the time. Right, so I'm going to announce my findings. As I stated, charge 1 is not taken into consideration. Regarding charge 2, I do find you violated the condition of absconder based on evidence provided, exhibits B, D, and X. Regarding charge 3, I do find you violated the conditional obedience to the law based on your conviction of criminal trespassing second and received an unconditional discharge, as well as exhibits that were provided to support that charge, exhibits B, D, and AA. Regarding charge 4, I do find you violated condition drugs based on evidence provided, exhibits B, N, O, Q, R, S, and T. And regarding charge 5, I do find you violated condition halfway house placement based on evidence provided in support of that charge, which is exhibit B, Y, Z, E through K, M, P, V, W, and X. So that includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, on behalf of Mr. Rice, my client, he's 49 years old. He was born in New York and he split his time growing up between Connecticut and New York. He did report to us, he has suffered some significant loss throughout his life. His mother, father, and sister, unfortunately, have all passed away. Upon his previous release from Osborne, he was at the Fellowship House in Groton, and then upon his other release, he was at the Open Earth in Hartford. As far as his education, he reported to us in 2012. He did complete commercial cleaning trade school while incarcerated at the Niantic Annex, which has since been closed. Looks like 2018 and 2019, he did complete a certified hospitality course and obtained his OSHA 10 at Enfield. And that was a 9-month program that he successfully completed. And most recently, while out in the community, he obtained his recovery coach certification, which is 100 hours through Connecticut Community for Addiction Recovery in New London. So I already indicated he was working at White's Furniture and Sleep Shop in Groton. That's the reason why he had the box cutter in his property. He was there for a few months. He did report to us. He did participate in a 12-step NA meeting with Connecticut Community for Addiction Recovery while at the Fellowship House, and also participated in intensive outpatient IOP at Southern Council on Alcoholism and Drug Dependence. This is a SCAD in New London. And also did report to us, he did complete a dual diagnosis intake assessment at Community Resources for Justice, CRJ. Through the clinical recommendation, was reported to participate with SCAD, which he did. So he did go to evaluation. They did recommend him treatment at SCAD, and he did participate in that. He did do some volunteer work at Connecticut Community for Addiction Recovery, CCAR, facilitating groups to obtain his volunteer hours to become a recovery coach. So I indicated that was a 100-hour program, which he did successfully complete. He's indicated to us since he's been incarcerated, he does remain in contact with the recovery coaches in the London community. And he's also reported he's been reading the 12-step literature as well. He is amenable to being placed in a halfway house or parole bed in the Bridgeport area. That's his first choice, but he's amenable to any jurisdiction. But it appears Bridgeport is his first choice. As far as his employment, he does want to complete the recovery coach requirement through CAR and amenable to any opportunities in the community until he can become a paid recovery coach. He is amenable to all treatment recommendations, including reestablishing and successfully completing the SCAD program. As I indicated, he did voluntarily put on the record at the preliminary hearing that he does have a substance abuse issue which he needs to address. He is willing to address that. He has successfully completed treatment in the past, but he did recover. As he, I believe, also at the preliminary hearing, he did admit shortly, a couple months after being released, he did relapse. Thus, the downfall. And these charges do reflect his usage. Thank you.
Thank you. So I'll be right with you with my recommendation. All right, there's a few things I'd like to put on the record. Offender was in the community about approximately 3 months before you returned to custody. You were only out there 2 weeks before you absconded from the halfway house. What's concerning is a short period of time that you are out before relapsing again already. And then you have a prior technical violation on this period of supervision in which you also absconded from the halfway house. You did receive the new conviction with an unconditional discharge. You are in supervision until February of 2033. So there is a substantial amount of time left that you're going to be with us. Your officer recommended a 1-year incarceration. You did receive 4 misconduct within that 2-week period. You were out in the community before leaving the halfway house. Based on the information I have, I'm going to recommend that parole be revoked and that you be re-paroled for April 14th of 2026. It's approximately a 6-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, mental health evaluation should be necessary. No contact with your victims. Subway 860 Maple Ave and Subway 65 Asylum Street, Hartford, and as well as JJ, NM, and JR. My findings are going to the parole board on December 31st. You will receive official decision from the board about a week after 12/31. During that week, the board can lessen that sanction. The soonest is 12/31. They can agree with my sanction recommendation of 4/14, or they can make a longer sanction than what I've recommended. If the board decides to impose a longer sanction than what I've recommended, you'd have a supplemental hearing, and the board would provide you with written notice, documenting the reason why they want to exceed that recommendation. During that hearing, you would have an opportunity to respond to those reasons while in front of the panel of the board. So just as you know, I mean, we have to wait to see what the board's decision is. I hope you can engage with some kind of treatment before you're out there, so you have a, you know, a start on that before you're going back out. Go ahead.
Nah, that's what I'm doing since I've been here. I've been involved with addiction
I know,
services now. So
I hope that
I've
you
been doing my best.
I know, I want to make sure that your head's in the right spot and that you can focus on yourself
I
before you go
appreciate
back
that,
out.
Ms.
'Cause
Manager. I appreciate
we're
that, Ms.
very-
Manager. I appreciate that because
I know if you're not using that, you're gonna do really well, and you were doing well, and I hope
everybody say
that.
that.
Yeah, and I hope you can see that, and you
Yeah.
can pick up from where you left and stay in the recovery and get
Definitely.
your recovery coaching, so that you can, you know,
I
we don't see
definitely
you
want-
again.
That's what I want to do. I definitely want to do that. Yeah.
Good.
That's my thing. Yeah.
Good, and
I
then
just
you
messed
sound
up.
focused.
Yeah.
You sound
Yeah,
better,
I found-
so
Yeah.
I hope you listen to yourself, because you
I
know
got
what you're
you.
supposed to be doing. Attorney Sir, could
I
you
want you-
say anything?
No, I just want to, Mr. Rice, so it's going to the board on December
Okay.
31st. You and I will get a report shortly thereafter. If there's
Okay.
an issue with them not adopting that April 14th date, I'll set up a call with you and explain the next step to you. Hopefully they adopt the
All right.
recommendation, and you are on special parole. So if they adopt the recommendation, they have to release you on April 14th, okay?
Okay.
All right, good luck to you.
Yeah,
You're on-
Thank you
talk to
for
your,
everything, Alonzo. I appreciate you, man, for real.
No problem.
well, listen, talk to your parole officer if you're struggling, so that they can get you help before you go off, and we don't want you absconding anymore.
I got you.
You know, relapse,
Yeah.
okay? So talk to your officers out there.
All right, Ms. Messenger, I appreciate you, man. Thank you.
All right, good luck.
Lucky.
You're all set, sir.
Yeah.
All
Take care.
right, thank you.
Thank you, my singer.
Thank you, have a good day.
Yeah, you too.
Morning.
Morning, Mr. Corona.
Yes, ma'am.
Be right with you, have a seat.
Thank you.
Distracting you. All set. So we're here today for your revocation hearing,
Yes,
so
ma'am.
we'll get started with. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning Corona Ulysses number 267628. Today is December 17th, 2025. This hearing is being conducted via video at the BOPP Central Office in Hartford, Osborne Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Good morning. My name is Ulysses Corona. And my inmate number?
Yes.
267-628.
Thank you. And you have counsel here today?
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Corona.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better awaited evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation on one or more conditions of your parole, I will reinstate your parole, which means releasing you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am. Thank you.
Okay. The important rights today: the right to have an attorney present. You have counsel here. You have a right to see the written notice, charges, the violation. Did you receive the written notice?
Yes, ma'am.
You have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
Okay, so we now review the charge the state or officers bring against you and the information underlying each charge. The charge 1 or bail laws will be instant law. Your charging officer reported that on 10/23/25, CPA halfway house staff reported that a loud bang came from your room at approximately 12:13 a.m. You never came out of your room to report anything to staff, nor did you report any incident on first shift prior to signing out on a community pass. Approximately 5 minutes after the loud bang was heard, another client at the halfway house reported to staff that you became angry when the light in your room was turned on, and then you subsequently punched the hole in the wall. Upon further investigation and follow-up, another client also reported they directly observed you punch a hole in the wall after the light was turned on. As a result of your behavior and property damage, Troop H was contacted to investigate. As a result of the incident, Troop H subsequently arrested and charged you with breach of peace second, as well as in addition to criminal mischief third. Based on your behavior, this places you in clear and direct violation. Your signed parole conditions, specifically under bail laws, as you engage in active crime. Charge 200 additional conditions, halfway house placement. Your charging officer reported on 10/6/25 during a smoke break. You were heard directly by halfway house staff making comments toward another client of the program who was Asian descent. You made comments, Chinese people are the worst. Look it up and Google it. When halfway house staff asked you to stop, you then announced to everyone out on the smoke break, you all need to be genocide, and all of you repeated the statement a second time. Staff then asked you to go back inside. You later saw the same client of Asian descent and proceeded to run your thumb across your neck in a manner to mimic cutting one's throat and stated to all of you, based on your behavior and clear direct violation of signed parole conditions, specifically under halfway house placement. On charge 3 under mental health eval and treatment deemed necessary. Your charging officer reported on 8/13/25. You attended an appointment at Wheeler Clinic for a mental health evaluation. Wheeler then clinically recommended you to attend an appointment on 9/8/25 with a psychiatric prescriber. You failed to attend your appointment on 9/8/25. This behavior places you in clear and direct violation of your signed parole conditions, specifically under your additional condition of participating in mental health eval to include a treatment deemed necessary. By failing to report to your prescriber appointment, you violated the additional condition as your stipulation failure states treatment deemed necessary. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, PCS conditions, B, halfway house agreement ×2, C, offender misconduct for failing to attend MH appointment, D, CPA halfway house IR for 10/6/25 incident, E, offender misconduct for 10/6/25 incident CPA, F, request to remove letter from CPA halfway house, G, CPA halfway house IR, H, statements and photos from 10/23/25 incident, I, police report Troop H, case number ending in 736, J, remained in custody order, remained at 10/23/25, K, notice of parole violation, L, notice of parole rights, M, parole violation report.
Fucking bastards. Yes. Yes, ma'am.
Don't say any comments at this time.
Oh, no, I'm listening. No.
Okay.
I didn't think you could hear me.
I can hear you.
I'm reflecting on the inaccuracies, but I didn't think you could hear me.
Yeah, I can hear you clearly, so don't speak right now. And the state has filed the following exhibits that, as I just stated, A through M. Did you receive notice of parole violation report, and those other documents I marked? Did you review them?
Yes, I was.
Okay.
I had seen that. Yes.
Okay. Council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and feature plans for parole reinstatement. Do you need to continue to obtain any additional evidence?
Yeah.
Okay, we don't have any witnesses. I did receive an addendum from PCS. The addendum reported on 10/31/25, offender was convicted of criminal mischief third and breach of peace second and received an unconditional discharge. So right now it is defense's opportunity. If you'd like to speak to any of the evidence submitted.
Yes. I think that addendum's not accurate. Thank you. In regards to charge 1, obedience to the law, I will just note that the addendum is not stated accurately. My client was convicted on October 31st of 25 to criminal mischief in the 3rd degree, where he pled guilty under the Alford Doctrine and received an unconditional discharge. The charge of breach of peace in the 2nd degree was nollied at that time.
Breach of peace, second nollied.
Yes.
And then my only comments in regards to that charge is my client did enter his plea under the Alford Doctrine, which is indicative of the fact that he did not agree with some or all of the facts that were alleged in the case. But however, he did elect to enter into that plea agreement so that he could receive this hearing at a quicker pace. I would also note that Exhibit H, which was a statement taken from my client, also shows that he has always maintained a different set of facts that took place on that particular date in the halfway house. In regards to charge 2 under halfway house placement, my only comment in regards to that is that my client does dispute the allegations as they're alleged in that charge. And then in regards to charge 3 under mental health evaluation and treatment, I would just point out that my client was issued that misconduct. However, Exhibit C does indicate that that appointment was rescheduled for September 18th of 25. There's no documentation submitted by Wheeler Clinic to suggest that my client didn't then attend the rescheduled appointment. And also there's no documentation submitted from Wheeler Clinic to say that he didn't attend the September 8th, 2025 appointment. There is an Exhibit E indicates that my client was then referred to CRT, Community Renewal Team, for the same exact type of treatment, mental health treatment. And again, there's no evidence to suggest that he did not attend those appointments. In fact, he does maintain that he was attending CRT up until the time of remand and had completed 2 classes at that point. So we would submit there's insufficient evidence to support a finding on charge 3. Nothing further as to the charges.
So I'll be with you with my findings in a minute. So I'm going to announce my findings. So regarding that charge 1, I do find you violate the conditional obedience to the law. This is based on your conviction of criminal mischief 3rd and received an unconditional discharge. Noted that breach of peace 2nd charge was nollied. On charge 2, I do find you violate condition halfway house placement based on evidence that was provided, which is exhibits A, B, D, E, and F. Regarding charge 3, condition mental health eval, making no finding due to there being insufficient evidence to support that charge. That includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you. My client is 49 years of age. He's single. He receives his significant support in the community by way of his significant other, Annie, his mother. He has 2 sisters in the Hartford and the Britain areas, as well as his father, who resides in the Dominican Republic. He is a high school graduate of Hartford High School. He attended the University of Hartford and completed 15 credits there, as well as attending Ohio University, where he completed 11 credits. In both, he studied architectural design. He was in the community, I believe, for approximately 6 months prior to his remand to custody. I believe this is his first violation of his parole. During the time period that he was in the community, he successfully completed the Community Solutions Halfway House Program Watkinson House in Hartford. He also sponsored successfully to his sister's residence, and then went to the Community Partners in Action Halfway House, and where he was at the time of his remand. He reportedly participated in the construction program at Capital Workforce Partners, Best Chance for a Second Chance. Also completed requirements for OSHA 10, scaffolding, forklift, traffic flagger, as well as CPR. He also was working on his personal health, utilizing gym, walking, running, biking for fitness, which was also helping him maintain a good mental state. In addition, he reports that he completed his intake at CRT and was attending weekly sessions, individual sessions with them, indicating that he had completed 2 of those sessions. Was also attending religious services on Sunday. During the time period that he's been within the Department of Corrections, he reports that he continues to attend religious services. He expects to begin working as a tutor. That may be something that he has accomplished since I've last spoken with him. In terms of his future plans for parole reinstatement, He indicates that he would like to sponsor his sister, who had previously been an approved sponsor, and her information is contained in Defense Exhibit 1. Yes. Also, he would like to continue his education by obtaining a bachelor's degree focusing on architectural design. He's open to all employment opportunities. He does have a history of working landscaping, construction, amenable to all treatment recommendations, and indicates that he would like to reestablish services working with CRT. He has been in custody on this remand since October 23rd. We would ask that you issue a sanction not to exceed 3 months. Thank you.
Thank you. So I'll be right with you with my recommendation. All right, a few things that I would like to place on the record. Defender was in the community approximately 6.5 months before he was returned to custody. This is his first violation of parole on this term of special parole supervision. He did receive 2 misconducts while in the community, as well as did receive a new conviction for criminal mischief third, in which he received an unconditional discharge. The parole officer is recommending a 8-month sanction. Based on the information that I have, I am going to recommend that parole be revoked and that the offender be re-paroled for February 23rd of 2026, approximately a 4-month period of confinement as a sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, and mental health evaluation and treatment deemed necessary, general no contact with Anthony Abreu Paban and Tyson Poe, and behavior management program for anger management. My findings are going to the parole board on 12/31. You should receive official written decision from the board about a week after December 31st. The board can lessen my sanction, let it stand, or impose a sanction longer than what I've recommended. If the board wants a longer sanction, you'd have a supplemental hearing. And before that hearing, the board would provide you with a reason why they may want to exceed my recommendation. During that hearing, you would have an opportunity to respond to those reasons while in front of the panel. Do you understand, sir?
I just wanted to, I finished the anger management program at Wheeler. I don't know if
Okay,
you would
well,
recommend it.
it's gonna stay on there. It's up to the officer to see if they would like you to redo it or not.
Oh, you recommend I retake it?
Well, it's staying on there in the event that your officer feels that you need to attend it again. I'm not sure if they're gonna deem it necessary. If you already completed it, because of this incident that occurred in the halfway house, they may have you retake anger management. So it's gonna be up to your supervising officer. I'm just not removing it, so it's gonna stay on there, and if they feel that because of this incident, you need to, that's why it's on there.
You were commenting on how my certificate was received by the halfway house when I finished the anger management on the pass from the halfway house. I didn't know if you were referring to that or if you were recommending additional anger management. That's why I asked.
If your officer feels it's necessary, then you would redo it if that's what their plan is with you. They'll discuss it with you though when they meet with you. Okay, so you are all set for now, sir.
Thank you.
Have a wonderful day. You too.
Thank you.
Thank
you.
You want? Yep, you can go back. You want?
Good morning.
Good morning, Mr. Hathaway.
Yes. Good morning.
I have your attorney here, Attorney Dean.
Nice to finally see you, Ms. Dean.
So we'll get started in 1 minute, okay?
Yes.
Good morning, I'm P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing for Hathaway Robert, number 292-230. Today is December 17th, 2025. This hearing is being conducted via video at the VOPP Central Office in Osborne Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Robert Hathaway, 292-230.
And you have counsel here today? Please identify yourself for the record.
Yes, Hannah Dean on behalf of Mr. Hathaway. Good morning.
Morning. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact of each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better reader evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole since releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read your rights. Then we will review the parole violation charge that the state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present all relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, you have important rights today. Rights to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so we will review the charge that the state your officers bring against you and the information underlying each charge. The charge one under release section reporting, your charging officer reported on 8/5/25. You're expected to report to report parole to speak to your assigned parole officer regarding a domestic disturbance that took place the night prior. You eventually replied back via text, asked if you could come on 8/6/25. The following day, you were instructed that you could not report the next day and that you had to report on 8/5/25. You did not report on 8/25 as instructed. Charge 2, GPS. Charging off report 8/6/25. You're placed on GPS supervision. On this date, you were instructed to charge GPS for 2 hours per day and sign your GPS conditions. On 8/10/25, your GPS battery shut down from 9:48 a.m. until you charged again at 10:08 a.m. On 8/12/25, your GPS battery shut down from 11:36 a.m. until you charged at 11:41 a.m. On 8/13/25, your GPS battery shut down from 1:11 a.m. until you charged it at 1:30 a.m. Charge 3 and obey all laws of being said law. Your charging officer reported, I separated this into 2 parts for the 2 different dates. Part 1, 8/5/25, you assaulted your victim at your shared residence. Your victim was asleep and you spit in her face and struck her on the right side of her face. Your victim attempted to get away from you and then you struck her again on the right side of her face and picked her up and slammed her on the floor, causing pain in her right side. The victim began to yell for help and her daughter called 911 for assistance. You then left the residence. You were instructed by your parole officer to report to Hartford Police Department to speak to an officer and you failed to do so. So you were contacted by Hartford Police Department to obtain a statement and you did not return the call. Subsequently, a warrant was written and signed by a judge for breach of peace second, assault third. You were given a PTA and are scheduled to be in court 8/25/25. Part 2 states on 2/24/24, Plainville Police was dispatched to an address in Plainville for unknown 911 hang-up where a female was asking for assistance. Upon arrival, a female victim stated that Mr. Hathaway and her got into a verbal argument over the status of their relationship. Mr. Hathaway became angry and began to smash plates and break glassware on the counter. The victim stated that once Mr. Hathaway heard her on the phone with 911, she left the residence. Subsequently, a warrant was written for your arrest for disorderly conduct. You were sentenced on this charge on 3/13/24 and were given a nollie. And the state has filed the following exhibits that are pre-marked for identification purposes. As Exhibit A, signed statement understanding agreement conditions of parole. B, signed GPS conditions. C, remand to custody order. D, violation notice of parole. E, parole violation report. F, arrest warrant, Hartford Police Department. G, arrest warrant, Plainville Police Department. H, offender misconduct reports. I, Allen University GPS reports. J, VOPP decision information summary. And K is photos of text messages. Did you receive notice of parole violation report, and those other documents I marked? And did you review it?
Yes, we have.
Yes, sir.
Okay, and council has filed the following exhibit that is pre-marked for identification purposes, Defense Exhibit 1, which is list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
We do not at this time, no. Thank you.
We have no witnesses today. I did receive the addendum from PCS. The addendum reported per GA 14 for a family violence case ending in 2618. Breach of peace second degree was nollied and assault third. Defender was found guilty. Both parties were disposed of on 11/21/25. Defender received an unconditional discharge for that. So there's now defense opportunity. If you'd like to present any evidence or speak to any of the evidence submitted at this time.
Yes, thank you very much. Concerning charges 1 and 2, I would just note that in the evidence I received, the client's list of parole conditions is signed and dated as March of 2019, which predates his current term of discretionary parole, as I believe he was released on this term from remand on 9/18 of 2024. So I just wanted to note that for the record. Concerning the reporting charge, I just wanted to put a couple of other things on the record. I would argue there should be a no finding for that. I would indicate that in Exhibit K, I think it's clear from the
Which one
text
are you
message.
speaking? What are you speaking in regards
To the reporting charge 1.
Okay.
I would argue that there should be a no finding there. As to Exhibit K that was submitted, those were the text messages between my client and P.O. Shep. I think he made it very clear that he was not by any way, failing to report that day, but that he just straight up, sincerely didn't have a ride. He indicates that he, was unable to afford an Uber up there, but that he would have a ride there the first thing the next morning. I would note that her reply then indicated to let her know when he's on the way, and if she's not there, that he'll meet with someone else. So I would indicate, those text messages suggest that perhaps he was able to make, additional arrangements. I will just also note that, my client indicates he did go to meet with his PO on that date per the text messages, but indicated that there were several text messages that weren't included here that explain more of this conversation with the PO. He then indicates that, his PO at this time didn't explain to him that the police wanted to speak with him. He thought that by going to the PO, he was turning himself in, but then this warrant came out later that was served for the conduct he was trying initially to turn himself in on. So my client, I do just want to make a record of, would have been willing to participate and cooperate with the police if his PO had explained that to him and given him the opportunity. As to charge 3, obey all laws, I just want to note no comments other than to note that the addendum is accurate. My client only received that one unconditional discharge sentence on the misdemeanor count, and the other charges that were pending were nollied. He didn't receive any time to serve or additional supervision. And then at the appropriate time, I would like to speak to his background and history if needed. Thank you very much.
Thank you. So I'll be with you, my findings in a minute. Okay, so I'm gonna announce my findings. So in regards to charge 1, I do find you violate condition reporting based on evidence provided, exhibits A, E, K, and H. Regarding charge 2 GPS, I do find you violated that condition based on evidence provided in support of that charge, which is exhibits A, B, I, and H. Regarding charge 3, part 1, I find you violate conditional obedience to the law based on your conviction of assault third and received an unconditional discharge. And regarding part 2, I find you violated that. Regarding this is on the date of 2/24/24. This is based on exhibit G that was submitted. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to at this time.
Yes, thank you very much. My client, Mr. Hathaway, is 41 years old, born and raised in Hartford. He reports a very strong family support system comprised of his cousin, his grandfather, his 2 siblings, sister and brother, and his mother-in-law. My client has 2 children, ages 5.5 and 5. He reports caring for his daughter while in the community and is very eager to get back to doing so. Most recently, upon release to parole, my client utilized Chase Center before transferring to Watkinson Halfway House, which he did successfully complete. He was also sponsored by his cousin and then self-sponsored at 2 different residences in Hartford. Concerning employment, my client was full-time for over a year at Target Distribution Center. He also has employment experience at Domino's Pizza Distribution. While at Watkinson House, my client participated in the Reasoning and Rehabilitation Group. He was also attending CRT in Hartford, where he started anger management. My client reports having an appointment scheduled in August of this year, where he was trying to obtain his driver's license. Upon reinstatement of his parole, my client would like to be sponsored by his cousin, Mr. Starks, at the address we provided. He is asking that if he's placed in a halfway house, he would like to be in the Hartford jurisdiction. My client plans to attend tractor trailer training school and obtain his CDLA after obtaining his license. He reports being able to return to that full-time job at Target Distribution and is very eager, as I stated, to get back to caring for his daughter. He's amenable to any sort of treatment recommended, including successfully completing domestic violence programming. I also just wanted to note that I think it's relevant. He has had no DRs in the past 10 years since being incarcerated. My client has been incarcerated, I would note, since August of 2025. And in that time, he's had, like I said, no disciplinary reports. His parole is completed as of June of 2026. And my client, I think, would really benefit from the assistance of supervision for a few months in the community prior to his EOS date so that he can get back on his feet, get set up with some programming, and get assistance with reentry back into the community. For those reasons, I am asking that you consider a sanction not to exceed 4 months for my client. Thank you very much. Mr. Hathaway, is there anything I left out that you want to state regarding your background or your future plans at this time?
No, you basically covered it. I definitely plan on obtaining my license and going forward with trying to train for my CDL. So after I'm off of parole, I can drive trucks. That's a career that I'm looking forward to.
Thank you very much.
Thank you.
I appreciate your statements. I have listened to testimony today. I reviewed all the evidence that was provided by the state. There's a few things that I'm going to put on the record. You were in community about 1 year and 5 months before your return to custody. You are on discretionary parole supervision. You did receive the new conviction for assault third, in which you received an unconditional discharge that was related to domestic violence. It is noted that you did violate 2 times prior on this period of supervision for instances that were domestic violence related. It is noted 2 times it was with the same victim. You did receive 2 misconducts. So it says your 3rd violation on this period of discretionary parole supervision. So obviously, I mean, that's something that's very concerning, that we do take very seriously. Based on the information, I do recommend parole be revoked. You remain incarcerated until your end of sentence date of 6/28/26. This is an approximate 10-month sanction. My findings go on the parole board on 12/31. You will receive official written decision from the parole board about a week after December 31st. Obviously, the board can lessen that if they would like to. If they want to let you out prior, they will. or they can agree with my sanction of the US date of 6/28/26, which it is currently at this time. Obviously, if you get rec credits, that will go down. Do you have any questions?
I don't get any good time, I know that. I have the bare minimum, I have the mandatory minimum of my sentence. So you're saying that I will see parole again before the 28th of June?
No, I'm gonna present your case to the parole board on December 31st. So the board, as you know, because you've been through this before, can agree with my sanction of maxing you out until your end of sentence date, or they can let you out sooner at any point after 12/31. So it's gonna be up to the parole board.
Mr. Hathaway, if you would like to call my office on December 31st, that's the date that they are reviewing a recommendation. We can let you know what they decide. They could do one of two things. They could give you the recommendation that she had, which would give you, your EOS date, or they could potentially give you less time if they think it's appropriate, but we'll know for certain on the 31st, okay? And if you have any questions concerning what they do recommend or what they do adopt, I can definitely set up another call with you.
Yeah, and you will get it in writing about a week after December 31st, what the board's decision is. So you'll get something from us letting you know what their final decision is.
Okay.
Okay, so you're all set today, sir. Wish you
Right.
best of
Thank
luck.
you, everyone. Have a great
Thank
day.
you. You too. Bill Walker, are you there?
Yeah, I'm here. I'm sorry. I'm officer of the
Perfect.
day, so I kept joining and leaving, joining and leaving.
No problem. We're all here. Good morning, Mr. Torres.
Good morning, ma'am. How are you doing today?
Good, how are you?
I'm not too bad.
You look like you're doing better than you were the first time I saw you.
Yeah, I got, I got up
That's
out the
good.
wheelchair.
That's
so
good.
I'm doing a lot better.
Good. Well, it's good to see that. All right, so we're gonna get started today with your revocation hearing. So good morning, I'm Theo Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing, St. Torres Vincent, number 433826. Today is December 17, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
My name is Vincente Torres, inmate number 433826.
Thank you. We have parole officer present. Can you please identify yourself for the record?
Yeah, it's Pro Officer Walker out of the Hartford office.
Thank you. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means at least you place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officers bring against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all of the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No, I do not, ma'am.
Okay, the important rights today, the right to have an attorney present. Would you like to continue without counsel?
Yes.
Okay. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, I do.
Okay, so we'll now review the charge the state your parole officers bring against you and the information underlying each charge. So P.O. Walker, will you please read the charge?
Sure. Obedience to the law. On or around 10/11/25, according to Connecticut State Police, you drove a motor vehicle under the influence of alcohol and without a valid driver's license, as you only have a Connecticut learner's permit. Upon approach and being questioned by the state trooper who was on foot, you took off in the vehicle at a high rate of speed. The vehicle was later observed partially in a ditch on the side of the road. You exited the vehicle and were observed by the trooper attempting to flee from the scene. You sustained a laceration to your forehead and required assistance to walk out of the woods, possibly having broken your right leg. You admitted to drinking 2 twisted teas prior to driving the vehicle and ran because you are on probation. I put in parentheses parole. EMS arrived on scene and you were transported via ambulance to Hartford Hospital. Subsequently, you were arrested and charged with the following charges: illegal operation of a motor vehicle under the influence of alcohol and drugs, evading responsibility, injury, property damage, interfering with an officer, resisting, and operation of a motor vehicle without a license.
Thank you. Can you please read the addendum?
Sure. Mr. Torres appeared in Rockville Superior Court on 11/25/25 regarding that docket matter. He was sentenced to 60 days on the charge of interfering with an officer, resisting, and illegal operation of a motor vehicle under the influence of alcohol and drugs. All other charges for the dockets were nollied, and he has no further pending charges at this time, and revocation proceedings may continue.
Thank you. And the state is following exhibits that are pre-marked for identification purposes. Exhibit A, signed statement of understanding agreement, conditions of parole. B, remanded custody order. C, notice of parole violation. D, parole violation report. E, state of Connecticut Department of Public Safety investigation report ending in 2711. F, state of Connecticut District Branch attempt surrender statement. G, state of Connecticut Board of Pardons and Paroles decision information summary. H, state of Connecticut Board of Pardons and Paroles written decision form. I, state of Connecticut District Branch pending case details, docket matters ending in 830. As well as 8449. Did you receive a notice of parole violation report, and those other documents that I just marked, and did you review those?
Yes, I did.
Okay. Do you need to continue the hearing to obtain any additional evidence?
No.
Okay. We have no witnesses today. At this time, I'm going to swear in P.O. Walker as well as you, Mr. Torres, in the event that you would like to speak today. So can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
I do.
So, thank you. So at this time, the state will have an opportunity, if they'd like to present evidence, to speak to any of the evidence submitted. You may at this time in regards to the charge, if you'd like to.
I have nothing further to add regarding the evidence. The case is what it is, you know, it was just the charge. We had no other violations or charges.
Thank you. So now is your opportunity to respond to parole violation charge against you. Or remember that you may remain silent if you so choose. Would you like to speak at this time, Mr. Torres?
Yes, I would.
Go ahead.
I just want to, put it out there that I was home for about 2 years, prior to this, and I just made a really stupid mistake. I was in school, I was working, taking care of my children. I was top 3-4% of my students at the school. I was supposed to graduate in like 6 months after this situation that happened. It was just a bad night, and I just made a risky, stupid decision, and I'm paying for it forever now as well because I have a plate in my leg. The original plan before this stuff had happened, I was saving up money to get my tattoos removed on my face and on my hands and neck, and I was gonna try to get into the Army. I was doing everything right. It was just that one mistake which costed me a lot. And I take full credit. I take full blame. This was nobody else's fault but my own. It was just a stupid mistake and stupid choices on my end. That's really it.
Thank you. I appreciate your statements. So what I'm going to do next is I'm going to announce my findings in regards to that charge. So on that charge 1, I do find you violated that condition, obedience to the law. This is based on your conviction of interfering with an officer resisting an illegal operation of a motor vehicle under the influence of alcohol or drugs and received a sentence of 90 days jail. I have the EOS date on that new sentence as January 23rd of 2026 with a PED date of 12/24/25 regarding that new charge. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose part of this hearing is to help, this part of the hearing is to help determine what outcome I will recommend. So at this time, P.O. Walker, would you like to make any statements?
No, everything that he spoke very well for himself and everything that he said is accurate from my recollection and my supervision of Mr. Torres.
Thank you. All right, Mr. Torres, now your turn. Would you like to tell me about anything in regards to release plans, anything you've been working on, you may at this time?
As to like, release plans pertaining to what?
Well, you're gonna be going back out. Do you have any plans to go back out?
Oh, yeah, absolutely. I go back to school and continue trying to save my money to get these tattoos removed. I know like my army plans are very slim now because I have a plate and screws in my leg, but I still want to get the tattoos removed so that way I could, you know, get a better job. I just keep moving forward, not drink. I know I talked to my fiance. She does want to get married with me as long as I, go to AA meetings and other stuff like that, so that's another thing I have to look forward to. Just continue doing what I was doing, just minus the drinking.
Where do you plan on going to?
So there's 2 spots. So my original address that I had originally paroled to, which is my mother's house on Vernon Ave. And then we're figuring out if I want to move into my wife's house as well. So it's either between those 2 spots. If anything, I'll just, whatever's quicker, truthfully. I don't care if I have to move back to mom's house. I'm sure she'll love to have me back.
What was your mother's address?
335 Vernon Avenue.
Where's that?
Right in Vernon.
Vernon? It's on Vernon, it's on Vernon Ave in Vernon?
Yes, ma'am.
Okay. What's your mother's name?
Jeanette Torres. And then my fiance lives in Vernon as well. She lives on 70 Old Town Road, Unit 310 in Vernon as well.
So what do you plan on doing in regards to, I know you said you're not going to drink. What do you plan on doing to remain sober?
AA meetings, work more. Don't give myself any free time because the moment I see that I have free time and something goes wrong, I just make stupid decisions. So keeping myself busy, whether that's working on cars, spending more time with the kids, spending more time with my wife, or even my mom, my grandparents. Just my main goal is to keep myself busy. I don't care if I have to read books.
Where do you plan on working? You said you have a job or you?
So I do work, but it is technically under the table. I work with a buddy of mine. He's teaching me stonework, chimney work, stuff like that. Just because no job that would hire me could really work with my school schedule. And I do pick up my 2 daughters after school. So it was kind of rough finding a job that would bear with me. At least until after I graduate.
Are you going to finish school?
Yeah, absolutely.
Okay. And where was that at?
And Lincoln Tech, right in East Windsor.
Okay. And what was it for?
Auto technician.
All right. Is there anything else from either side at this time?
I have nothing further.
Okay. So I'll be right with you with my recommendation. There are some things I do want to put on the record. You were in the community approximately 2 years and a month before you returned to custody for these new charges. You are on discretionary parole supervision. You did receive the 2 new convictions in which you received a 60-day jail sentence with the U.S. date on that of January 23rd and 26th is what I previously stated. There's no prior violations or misconducts received. You are done with your sentence as of March 21st of 2026. So it's not really, you don't really have that much time left either. Based on the information I have, when your end of sentence date is, I'm gonna recommend that parole be revoked. You remain incarcerated until that EOS date of March 21st, 2026. That's a like 5-month sanction as of right now. Obviously that date, if you get rec credit at all, I'm not sure if you're going to, because I'm not sure if you have a mandatory minimum on that, which you may. But you have between the end of sentence date of 123 and 321, you have less than 3-month period for supervision. So I'm going to present this to the parole board on December 31st. So the board, if they want to let you out sooner, the soonest they can let you out would be 12/31. They can let you out anytime between then. If they would like to give you that small remainder of time, they may. Do you have any questions?
Yeah, I just kind of don't understand what just happened.
So I recommended your end of sentence date because you're not done with the new sentence till January 23rd. In between then and 3/21, there's not much time left to even be released. So my recommendation is 3/21/26. I'm presenting this to the parole board. Mine's just a recommendation. So December 31st, the board's gonna make the final decision. So they can let you out as soon as December 31st if they would like to let you out. Then in any time in between your end of sentence date, they may. So if they wanted.
I'm sorry, Dad. So I'm going to the parole board again on the 31st.
You are not going anywhere. I am presenting your case to the parole board. So the board can agree with me, or they can let you out sooner if they would like to. So if they decide, yes, we want to let you out, they're going to give me a re-parole date, and then you're going to get your conditions, and then you'll get that all in writing. So a week after December 31st, you're going to get it in writing from them, from us. We're going to send you what happened at the board review, and it's going to have, if they agree to either let you max you till 3/21, or if they decide to let you out, then you'll have your re-parole date on there, which is an on or after date because you're discretionary. And then it would have your conditions if the board decides they would like to release you. Okay,
thank you.
So I wish you the best of luck, sir. You sound like you were doing great before. I hope you make better decisions, and hopefully we never see you again. And I wish you the best of luck.
Thank you.
You're all set.
Bye, Mr. Torres. Good luck.
Thank you, Field Walker.
All right, thank you. You likewise. Thank you.
Thank you.